Okay, we started this hearing more than a year ago.
That's correct, Your Honor.
We had one partial day of evidence. We were on direct of witness number one, and we need to continue with witness number one and including cross-examination. But since we started this hearing, the hearing has morphed a little bit. There have been quite a number of additional disclosures. There have been supplemental motions to dismiss filed, two of them, as far as I can tell, one purporting to describe certain prejudice from the late disclosures, and one on a different grounds relating to Michael Proctor. And so when we spoke last time, I think I talked about being able to opine myself in advance of which witnesses we would be calling. I saw that stuff was recently filed, and I saw it too late to make that call, nor do I think I would be very good at making that call based on what's been presented to me. This is really two prongs: late disclosure and any prejudice from that late disclosure. So those are two prongs of the same issue.
Yes, sir.
And number two, bias in the investigation as a result of Mr. Proctor's strongly held views and strongly articulated views. And I wanted to hear from you as to what we should do next. It seems to me we have to finish Mr. Lally's testimony. I have a full afternoon, unfortunately, so we have all morning. We have until 1 o'clock. Hopefully we can get Mr. Lally finished today, and then we can have further discussion about whether there is any evidence needed on the second supplemental motion relating to Mr. Proctor, and what additional witnesses we need with respect to the first issue. Yes. So I'm only saying this because it's like speaking out loud. I'm trying to frame the issue as best as I understand it. So anybody who wants to tweak that understanding, I'm welcome to. I'd be welcome to hear from you.
So, Judge, I guess I had a question regarding the additional witnesses. Does the court want to hear argument on that, or are we going to be allowed to call them, or are you going to decide witness by witness?
I think we should hear what it is that you're and why they're being called, okay?
Yes,
and we should have that conversation. But I got a one-paragraph description, maybe that's all I asked for, about what they...
One paragraph description per witness.
And, you know, I appreciate that, and it helped you each think about whether that person should be called, but I'm not sure that I could flesh it out enough, okay? So... I'm guilty of my own inventiveness. So, you want to start with Mr. Lally and see if we can get Mr. Lally on and off the stand, and then we can have further conversations?
Sure, Your Honor.
Okay, he's testifying as to the first part of the motion, the issue of
I don't know if it's limited.
Timing of disclosure and potential prejudice.
I don't know if it's limited to the first part of the disclosure because he worked with Trooper Proctor, so I'd be asking him questions regarding Trooper Proctor as well, Judge.
All right, we can take those up if there's an objection, okay?
Sure, Your Honor.
Okay, we can recall Attorney Lally.
Oh, Judge, can I ask one question?
Sure.
My client has handcuffs on him, and I spoke to the court officers. I'm wondering if the court would authorize him to have the handcuffs undone for the purposes of this hearing so he can take notes.
That's okay.
Thank you, Your Honor. For them to take off the handcuffs. Thank you, Your Honor. I appreciate it.
Mm-hmm. Mr. Lally, we started your testimony in the other room back in July of 2025. You were sworn at that time.
Yes.
And I'm going to remind you, for purposes of this hearing, you're still under oath, okay?
Absolutely, Your Honor.
Okay.
May I, Your Honor?
You may.
Thank you.
You can be seated if you want.
Morning, Mr. Lally.
Morning.
So last we spoke, we were talking about your involvement in Mr. King's case as the assigned Assistant District Attorney. Do you remember that testimony?
Yes.
Okay. The testimony has been transcribed. All of the parties have it. So I'm not going to go over any of that testimony. I think we're going to move on to issues that are relevant to this hearing. The first thing I want to talk to you about is, I'm not sure if we have Exhibit 1 or if we need a new copy of Exhibit 1. Need a new copy, please. We have it, or we need a new copy. Let's talk to Mr. Lally about it. May I please?
Sure.
This is just a motion. I'm showing you a document, Attorney Lally. Can you tell me whether or not you recognize that document?
I believe so, yes.
Okay. And does that give you the discovery motion that I filed with the state?
It appears to be yes.
If I can just, what's the date of that document?
What I was going to do, Judge. 12/22/21.
Okay.
I move to introduce the judge.
It may have been marked as Exhibit 1 before, right? Everybody thinks this is what was marked as Exhibit 1?
Yes.
All right, so we'll remark that as Exhibit 1.
So, Mr. Lally, when you received that from me in December of 2021, what did you do?
I did what I do with any discovery motion that I received from counsel, and I forwarded to all involved police departments in the case and make requests basically to fulfill whatever you or any other counsel is looking for in terms of discovery.
So in this case, who'd you forward it to?
In this case, I would have forwarded it to probably Trooper Proctor as the case officer and Lieutenant Collins from Milton PD.
So to the state police and to the Milton Police Department, is that right?
Yes, I mean,
would you have forwarded it to anyone else?
Hold on, let him finish.
I'm sorry, Judge.
No, all I was going to say is potentially someone else, depending on the contents. I don't recall if it had something to do with the lab or the medical examiner's office or something, some other agency, then I would have forwarded to that agency as well.
And then once you forwarded my discovery request to at least the state police and the Milton police, what did you do to follow up on that?
If there were materials that were discoverable within the motion and I hadn't received them, then I would have followed up to find out what the status was or what was going on with those particular items.
So wait a minute, who's making the determinations as to what's discoverable? Is that the state police and the Milton Police Department, based on you sending them the motion?
Discoverable is a wrong term. What I meant to say was whether or not they had them in their possession, whether or not it was something that they had in their custody and control, because there certainly could be requests made within a discovery motion for items that just either don't exist or we don't have.
So when you sent this to let's start with the state police. When you sent it to the state police and you said Trooper Proctor, what response did you get from Trooper Proctor back in December of 2021 about the documents that would fulfill my discovery request?
I couldn't tell you.
Well, do you have any notes, or did you take any notes at the time about what Trooper Proctor represented to you that was in the file that needed to be disclosed?
If I did, I have not looked at notes or anything pertaining to the file in a very long time. I'm trying to answer your question, but I don't know.
So you didn't look at the file before you came here and testified today?
No.
You knew we were going to ask about the file, right?
I don't know what you're going to ask about.
Well, we asked about the file a year ago, right?
Yes.
And I asked you to review it then a year ago. Do you remember that?
I don't remember you saying that, but sure.
And then you knew you were going to be in here and be questioned about the file, right?
I don't know what you're going to ask me.
When we're talking about late discovery, do you think that the file that's contained in the district attorney's office is important to determine what was disclosed and what wasn't, Attorney Lally?
I'm sorry, what is your question?
When you're talking about late discovery, do you think what's contained in the district attorney's file is important to determine what was disclosed and what wasn't disclosed?
Certainly.
And you didn't do anything to look at that file, is that what you're saying?
To look at notes from December of 21? No, I didn't.
All right, how about your memory? What's your memory of what Trooper Proctor told you he had in terms of documents?
My memory and again, I mean, it's an ongoing obligation to provide discovery. So as the case moves along and more discovery...
We haven't gotten on yet, we're just talking about...
Hold on, he's not done.
Sorry.
So recognizing that there's an ongoing obligation to provide discovery, if there's any discovery that is generated, then it would be provided in the time that it was, as I did with the 26 notices of discovery and the 172 items of unique discovery that was provided to you over the course of the time that I was handling the case.
Oh, so you knew about those numbers. You just don't know about the file, right?
As far as
I don't know what you're referring to as the file.
The file in the district attorney's office that would have the information of what notes he took during the time that he represented the Commonwealth.
Okay.
He told us he kept a
that's just-
checklist.
This is not a jury trial, right? This is
I
a
understand
hearing in front of the court, okay? He did not review the file before coming in today. Next question.
May I be heard, Your Honor?
Yes.
Mr. Lally's been sequestered for, since last year. Additionally, he's not the prosecutor.
With an exception provided by me on request, okay? I understand that.
Thanks.
Go ahead.
So what did Trooper Proctor give you?
specific to this motion?
Yes.
I don't recall what, it's a 10-page motion. I don't recall everything that was listed within the motion.
If he was going to give you anything, when you got it in your office, how did you document it?
I'm sorry, how did I document what was provided?
Yes.
In the notice of discovery that was provided to you.
So the notice that was the discovery that was provided to me, that's the way you documented what the state police gave you? Is that right?
Well, as soon as I receive anything, as far as discovery is concerned, I don't wait for the next court date to turn it over. What I do is, as soon as I receive something, I make a copy of it, I forward it to counsel along with the notice of discovery and the cover letter attached to it.
So, but my question was, the notice of discovery that you provided in this case, and you said you provided 26 notices of discovery, that discovery came from Trooper Proctor, right?
Not all of it. I mean, there were items from other agencies, but anything from the state police presumably would have come from him.
From Trooper Proctor?
Correct.
Okay. And so my question to you is, when you get whatever you get, so how does Trooper Proctor give it to you? Does he email it? Does he drop it off? Do you have a conversation? How does that happen?
It varies depending on what it is. It could be any one of those things.
Okay. So do you know how many times you met with Trooper Proctor regarding this case and the discovery?
No.
And can you tell me when he sends discovery to you, whether it's by email or he drops it off or you have a conversation, how do you document that in your file?
I don't think I would necessarily document that I received a certain item on a certain day. Again, as soon as I receive it, what I do with it before the end of the day is I type up a notice of discovery, I make a copy of whatever the discovery item is, and I would then send it off to defense counsel.
Okay. And did you do the same thing with the Milton Police Department? You sent the motion to the Milton Police Department, is that right?
Yes.
And how would you communicate with the Milton Police Department about that, about documents that they have responsive to that discovery request?
In the same manner, as far as whether I couldn't tell you if it was a phone call or an email, but it was, I mean, as far as forwarding the discovery motion to them, that was done via email, but as far as, you know, any subsequent conversations in relation to it, you know, essentially what I'm looking for from every department in every case that I've ever done is anything and everything that you have.
And do you tell them that? This motion asks specific things, but I want anything and everything that you have. Did you say that to the Milton Police, sir?
Yes.
And did you say it to the state police, sir?
Yes.
Okay. And then did you keep track, I think you said last time you had a checklist of what was turned over and what was still outstanding. That was something you kept in your file, is that right?
I'm not sure what checklist you're talking about.
Well, you talked about a checklist last time we testified. You said the way you kept track of things is that you had a checklist, and when things were turned over, you would check it off. Remember that testimony?
I don't.
You know, is that what you did? Did you have a checklist?
So I would have a checklist when I first get assigned to the case as far as items that I'm looking for purposes of grand jury and for purposes of general discovery, because my intention is always to sort of front load the discovery and give counsel as much as humanly possible at the arraignment date. Subsequent to the arraignment date, if there was something specific that was either requested by counsel or there was a motion filed, then yes, I mean, I would keep that or do my best to keep track of, you know, what was outstanding and what we were looking for.
And was that by checklist like you talked about before?
So the checklist thing I think you're talking about is probably something that I do prior to indictment. So a checklist is sort of initially when I receive the file, then I'm going through it and trying to figure out, you know, what do we have in this case as far as evidence is concerned? Is there video? Is there photos? Is there some sort of grand jury subpoena for third-party records I need to do or what have you?
So with respect to let's start with the state police. when you received the documents from the state police, you immediately put together a discovery notice and send it out. Is that right?
Correct.
And the same thing with the Milton police, is that right?
Correct.
All right. And then at some point, I assume you looked through what they gave you, right, before you sent it out?
Well, I would, yes, review things before providing them to anybody, sure.
Okay. And did you make any determinations that anything that the state police gave you was not discoverable?
No.
Did you make any determinations that anything the Milton police gave you was not discoverable?
No. And to be honest, I don't think I've ever looked at any piece of discovery and said, I'm not going to give this to the defense attorney because I don't think it's discoverable. That I don't do. I don't make those calls. I think that's something for the court.
Well, you have to determine what's discoverable because you have to turn it over, right?
Correct. But what I'm saying is if I receive discovery, you as a defense attorney are getting it, whether, you know, we can argue later on whether or not it's admissible, but as far as you having access to it, you should have access to everything that I have.
Okay. So once you do the first round of discovery, did you believe that discovery was complete at that point, that the state police had complied with everything that I requested?
Yes.
You did?
As far as what existed at that time, I'm sure there were things in your motion that might become, you know, whether it was forensic testing or things of that nature that, you know, but as far as reports were concerned, everything that I had, you had. If there was going to be anything further, reports written or forensic testing that was conducted, then that would be provided as soon as we received it.
So it's your position that the first round of discovery, Discovery 1, contained all the information that the state police had up to the date that you disclosed that information, is that right?
That's my understanding, yes.
And what about the Milton Police Department? When you sent them the motion, is that the same thing? What they turned over to you was everything that they had?
That was my understanding, yes.
I want to be very clear about what your testimony is, Mr. Lally. Is it your testimony that as of the first disclosure, you had disclosed everything that you had or everything that the state police had?
So in the first disclosure, it would have been every single thing that I had. And if there was, I believe this motion is dated in December of 21, which was, I believe, around the time that Mr. King was arraigned in this court. So then that would have been post-indictment, post his arraignment, then that would have been forwarded to the relevant police departments and a request made to, you know, any and all materials that are contained within the motion or any other materials that the departments have, I need.
So let's continue about the Milton Police Department. So it's your position that when Milton responded to you in the first discovery motion, they gave you everything that they had generated through the date of that disclosure, is that right?
That's my understanding, yes.
Okay. Did you do anything to make sure that you got everything from the Milton Police Department?
Do anything further than ask for everything and been told that I had everything? No.
Well, let's stop there. Who told you you had everything from Milton? Who said you have everything we have? Who said that?
That would have been Lieutenant Collins.
Lieutenant Collins. So you had a conversation with Lieutenant Collins sometimes before you filed the first discovery notice in which he told you you have every document that we produced in this case through today's date. Is that what happened?
Yes.
Okay. And did you at that point say, let me see your file?
I did not, no.
Is there a reason you didn't ask to see the file?
I accepted his representation that I had everything that he had.
Okay. And you found out later that that wasn't true, right?
Correct.
So I guess my question is, when a police department tells you that they've given you everything, and you take that at face value that they've given you everything, is there any follow-up at all to say, let me see your whole box, let me see all your stuff, send me your electronic file, anything like that?
At that time, no.
Okay. So I guess the question is, how can you represent to the court that you've turned everything over? You're relying on the individual police departments to tell you that they gave you everything?
At that time in the case, yes.
Okay. So are they the ones that are looking at the discovery motion saying these are the things that King is asking for and these are the things we have to disclose, or are you saying give me everything?
Both. I'm giving them a copy of the motion so they can know specifically what you've requested, and then I'm also at the same time telling them to give me anything and everything, even if it's not encompassed within your motion.
Okay. So, I'm sorry, Judge. Did you?
No? Go ahead.
Okay. So you're doing both. You're saying you have an obligation to turn over all the reports, so you want everything, and then you're also showing them the motion saying this is what has been specifically requested, right?
Correct.
Because despite what's specifically requested, there's a Rule 14 obligation for you to turn over discovery, right?
Yes.
And discovery certainly encompasses police reports, is that right?
Yes.
And grand jury testimony, is that right?
Yes.
And any type of scientific testing, is that right?
Yes.
Witness statements, is that right?
Yes.
Okay. And in this case, from the Milton Police Department, who was it that told you that you had everything?
I'm assuming it's Lieutenant Collins. He was my primary contact with the Milton Police during the time.
When Lieutenant Collins told you that you had everything, you relied on Lieutenant Collins' representation that he had given you all of the reports, all of the interviews, all of the materials that were contained in his file, is that right?
Yes.
And you never did any follow-up to find out whether or not that was true, is that right?
No.
All right. So when do you do the follow-up to find out if you have everything? Because you filed 26 discovery motions in this case, right?
Notices of discovery, yes.
Okay. So 26 notices of discovery, we still didn't get all the reports from Milton. Is that fair to say?
That's my understanding now, yes.
So how did that happen? What happened there?
How does that happen?
Yes.
I couldn't tell you.
So at any point in time before filing these 26 discovery motions, do you make arrangements to go down to the Milton Police Department and look through their files?
No.
At any point in time while you were the assigned assistant district attorney in this case, did you go down to the Milton Police Department and look through their file?
No, because normally that is something that I do when a case gets a trial date.
When the case gets to trial?
No, not when the case gets to trial. When the case gets to trial date, I would then meet with each of the individual officers and make sure that there's nothing that they have that I don't.
Okay. And so do you do that on the day that the trial date is assigned, or you do it closer in time to when the trial actually is going to happen?
It depends. Depends on the case, depends on the complexity, depends on how many witnesses, depends on how much time would be necessary to prepare for trial.
So what happens when you finally do this review of their file, and you find documents that haven't been disclosed? What happens then?
Then that would be something that I would immediately turn over to counsel.
And what if it's on the eve of trial?
It would not be on the eve of trial. I don't meet with witnesses. I don't wait to meet with witnesses until the eve of trial.
What did you wait for in this case? How long did you wait?
This case didn't have a trial date when I...
Oh, it did. It had a trial.
It had a trial date, I think, 8 months after the fact, but it was also 8 months from the date when it was reassigned to Ms. Hickman.
When it was reassigned to Attorney Hickman, is that what you say?
Yes.
Okay. So it's your practice within the Norfolk County District Attorney's Office to ask for the individual police departments to give you everything and to send them the motion, but to not do any follow-up until there's a trial date. Is that right?
I wouldn't say that there's no follow-up. There were subsequent motions that you filed that, again, same practice as far as copying the motion and sending it to them. If there was anything that I became aware of that may exist, obviously I would follow up on that. But as far as when I ask them for everything and I get a representation that I have everything that they have, I assume that I have everything that they have.
I guess it's the assumption that I'm having a little bit of difficulty with. So instead of assuming, do you ever take it upon yourself to go look at the file?
We're talking about in this case?
In this case, yes.
Did you go down and look at the file yourself?
In this case, no.
And is there a reason for that?
No.
Because you understood it was your obligation to make sure that Mr. King got all of the discovery that he was entitled to, right?
Correct. Well, I mean, as far as the reason for that would be that I asked for everything and was told that I have everything. So I didn't feel the need to go down and look through the file myself to see if there was anything beyond that.
Were you ever trained within the Norfolk County District Attorney's Office to do your own searching through these files, to not rely on individual police departments to turn over discovery to you? Did anyone ever tell you that during training, that would probably be a good idea?
Not that I can recall, no.
Okay. And by the time you had Mr. King's case, how many years had you been an assistant district attorney?
By the time I was assigned Mr. King's case, probably 16 years.
So for 16 years, your practice was that you relied on the individual police departments to give you everything. And if you didn't get it, you waited until it's right before the trial to look through the trial file? Is that what you do? You look through the file right before trial?
No, not right before trial. I think that's not what I said.
Okay. But your practice is to rely on the police departments, individual police departments, to give you all of the discovery. Is that right?
Yes.
Your practice isn't to go to the individual police departments and look at their files, right?
At the point in time you're talking about, and when just after the defendant's been arraigned, no.
How about in the 26 notices that you filed? Before any of the 26 notices that you filed, did you go to the Milton Police Department and make sure you had everything?
No.
How about the state police? In the 26 notices that you filed, did you go to the state police to make sure you had anything?
Probably, yes, yeah.
You probably went to the state police.
Yes.
What does that mean?
What that means is, again, as a case is going on for the number of months that this case went on, there were, I would imagine, numerous conversations regarding discovery, whether it was a motion that you had filed or whether it was a motion that I had filed or different aspects of discovery that we were looking at, and those conversations would have been ongoing as far as, you know, ensuring that I had everything. That it's not like I would rely on a one-time representation at the inception of the case. Do I have everything? Yes. Okay, fine.
So I guess my question is, with respect to the state police, did you ever go and look at their files? While you represented the Commonwealth in the case of Commonwealth versus Myles King, did you go and look at the state police file?
No.
Did you have any idea in the 26 notices of discovery that you filed what the contents of the state police file was?
No.
What about the Milton police? In the 26 notices of discovery that you filed, did you ever have any idea what was contained in the Milton police file?
No, other than what I've been told, that I had everything they had.
Okay. In terms of discovery, so let's talk about police reports. So all of these police reports that are generated in 2025 by the Milton Police Department after ADA Hickman went and actually looked at the file, you understand that there was a number of police reports dated on the date of the incident or shortly thereafter that were never turned over to the defense. You understand that, right?
My understanding was one.
You only knew that there was one?
That was my understanding, yes.
So you thought there was one police report missing from Milton, not a bunch of police reports that ADA Hickman turned up when she actually went through the file?
My understanding is as far as police reports, there was one.
What about documents? How many documents did ADA Hickman copy and turn over to the defendant after she reviewed the Milton file? Do you know?
I don't.
Did anyone ever go back to you and ask you why these weren't turned over to the defendant?
No.
Did you ever talk to ADA Hickman and try to explain why these weren't turned over to the defendant?
As far as the why, no. I mean, the why is obvious. I wasn't aware of them, so they weren't turned over.
Okay, so why weren't you aware of them? Didn't anyone ask you that? How were you not aware of these reports?
No.
Nobody from the district attorney's office asked you why you weren't aware of these reports?
Objection.
Sustained.
Did Attorney Hickman ask you why you weren't aware of these reports?
Objection.
Sustained.
In any event, the reports get turned over in 2025, and you think it's one report that gets turned over in 2025. Is that your understanding of the late disclosures in this case?
My understanding as far as the police report, yes.
Were there other documents that were, to your knowledge, taken from the Milton file that weren't turned over?
Your Honor,
Yes.
may I be heard?
You may be heard.
There's been a number of notices of discovery that speak for themselves, and ADA Lally was not the prosecutor after December of 2025.
Right. I'm not sure I understand the relevance of what he knew about later disclosures by others.
Because he said there was one document, Judge. There's way more than one document, so I was going to get there.
But I don't understand what his knowledge in 2025 of later disclosures, how that's relevant to the question of why that stuff wasn't turned over.
Well, because he said it was one document, Judge, and I need to make a record of what was actually turned over by ADA Hickman.
All right, the record already exists in the file of what was turned over.
So are you saying that the court will take the Commonwealth's Notice of Discovery 28 as evidence in this case, Judge?
I don't see why not.
All of these notices of discovery are part of the record.
Right.
Additionally, and I'm happy to mark it, I don't want to go off on this tangent. We had those charts. I'm happy to mark the last one that we had prepared together about what's new and
Okay, that wasn't yet marked, but we can deal with
mark
that.
that at some point. Yeah.
So have you ever withdrawn from representing the Commonwealth in this case?
As far as a formal motion, no.
So you're still an attorney of record, right?
No, I don't believe I'm on the docket or listed as counsel of record on.
So when did you withdraw?
Again, did I file a formal motion to withdraw? No, but whether or not, I'm not counsel of record for the case.
So when did you stop being counsel of record for the Commonwealth?
I believe it was either November or December of 2024.
Of 2024?
I believe either that or early 25.
Okay. But you didn't file a motion to withdraw?
I don't believe so, no.
And you showed up at all the hearings when you weren't on trial in the Karen Reed matter, right?
During 2024?
24, 25?
25, no. I don't believe.
You didn't show up at any of the hearings in 25?
I don't believe I did. I'm not. That's why I said I'm not sure.
Okay. In any event, with respect to the state police, you said you spoke to Trooper Proctor, you asked him for everything, he sent you information, and ultimately you turned that over. Is that right?
Correct.
All right, let's talk about the search warrant. You realize that there were search warrants that were contained in the file dating back to 2021 that weren't turned over, right?
Contained in what file?
I'm sorry?
Contained in what file?
Objection to form of the question.
Let's have a question from the beginning.
Sure. Can I look at this one?
Yes.
Can you look at these documents and tell me if you recognize them?
I believe the search warrants.
Yeah, 21 search warrants. Is that back to 2022? Yeah. In terms of what I saw.
Generally speaking, yeah.
I didn't hear what you said.
Recognize them?
Generally speaking, I recognize them, yes.
Okay.
What do you recognize them to be?
They appear to be search warrants related to Mr. King's matter.
Related to what?
Related to Mr. King's matter.
Okay. And is it fair to say that these search warrant number, let me ask you, is it fair to say that these search warrants appear to be dated July 11th of 2021?
I didn't look at the date, but I'll take your word for it.
And just may I ask, are these the Bates stamp search warrants? These all Bates stamped in the top right hand corner?
We start at 282,
Thank you.
I believe.
Thank you.
Base stamp 282.
Thank you.
Would you
Sorry.
like to introduce the search warrant?
Any objection?
No, no, no.
All right.
How many are there? Oh, 6 warrants in total?
Yes. So Attorney Lally, you understood that there were search warrants in this case, right?
Yes.
And you understood that Trooper Proctor was the author of those search warrants, right?
Yes.
And you understood that he asked for certain information. I'm assuming he consulted with you regarding that. Is that right?
As far as the information he was seeking, yes.
Yes. Did he consult with you regarding a T-Mobile search warrant for cell phone number 6961?
I believe that was your client's cell phone, so yes.
Okay. And you understood that he had gotten permission to do a search. Is that right?
There were, I think, 4 warrants pertaining to your client's phone.
So is that a yes? You understood that there were warrants that were signed off on by a district court judge for information in this case, right?
Yes.
Okay. And when you looked at the discovery as it was being sent to you from Trooper Proctor, did you realize you didn't have the search warrants?
No.
Objection to form of question. I just want to be clear on,
There is a timing part.
or just what portion of the search warrants. I think the issue is the affidavit.
Well, you can take care of that on cross, can't you?
Let's just be clear about the question. Do you have them there? I haven't seen Exhibit 2. Let me take a look at them.
Thank you.
We have an extra copy.
So Judge, I have an extra copy. You can read along if you want with that copy.
Well, the material that I have here, you've handed up, some of it is base numbered and some of it is not. Some of it is clearly not search warrant affidavit stuff. I don't know what all this stuff is.
I'm sorry, Judge?
Some of this is search warrant, some of it's not. Some of it is underlying documents. I don't know what those underlying documents are. Maybe they're exhibits to an affidavit. I have no idea. They're not all Bates numbered. So I just want to make sure that there's no objection to this document. I know we just admitted it, but there were representations about it, what it was.
I believe it was all search warrant checks.
All right, if we could hand this back to the ADA.
You have a copy.
Yeah, that's fine. The Commonwealth wants to introduce their copy, that's fine, please.
Hang on one second. We're going to see what we're going to introduce.
Oh, is it?
So should we,
Let's just replace it with yours, that's fine.
by agreement, we're going to replace Exhibit 2 with
Okay?
clean copy?
We'll mark this as Exhibit 2. Attorney Scapicchio, take that sticker off of the document that I just gave back to you.
Absolutely, Judge.
Thank you. I'll take it.
Thank you.
Okay, now,
Mr. Lally.
go ahead.
Thank you. Mr. Lally, you understood when you reviewed the materials that Trooper Proctor was sending you that they didn't contain the search warrants that you knew had been issued, right?
I'm sorry, when I reviewed the material?
Yeah, you said when you got the materials from Trooper Proctor, you would immediately review them, and that same day, you would put a notice of discovery together and give it to the defendant. That's what you said, right?
Yes.
Okay. So when you reviewed the materials that Trooper Proctor gave you from the state police, you had to have known that the search warrants weren't there, right?
I didn't.
You did?
I did not, Your Honor.
Did
If
not, okay.
Had I realized, then I would have gotten copies of them and sent them to counsel.
So did Trooper Proctor give you the search warrants and you just didn't turn them over? Or are you saying Trooper Proctor never turned them over to you?
No, as far as what I provided to you, as far as discovery was concerned related to the search warrants, is what I had been provided by Trooper Proctor. I know that there was at least at one point a conversation in reference to there was not a partial affidavit, but an affidavit without an application return and copy of the warrant itself. And I never received it, therefore you didn't get it.
But you knew I was looking for it. Did you call Trooper Proctor and say, hey,
I did not.
Search warrants outstanding.
First
Can you
of
get me
all,
those, please?
Objection to,
I would disagree with that. I did not know that you were looking for it. I don't think it ever once came up as far as our conversations regarding discovery was the 2021 search warrants.
So are you saying that search warrants aren't Rule 14 discovery, sir?
I'm not saying that the onus is on you at all. I'm just saying when you say that you knew I was looking for it, I didn't because we never talked about it once.
Well, we talked about getting all the exculpatory evidence from Mr. King, didn't we?
In general
Done on
terms?
a number of occasions,
Oh,
right?
hold on. One question at a time. Which one do you want?
We talked about getting the exculpatory evidence from Mr. King, right?
As far as you filed motions to that effect, yes.
But you don't have to wait for a defendant to file motions. You know you have an independent obligation to turn over information to a defendant under the Constitution, right?
Of course.
And under Rule 14, right?
Yes.
So you didn't need a motion to say we needed search warrants, but if you needed one, Exhibit 1 also asks for search warrants, doesn't it?
I don't know.
Well, did you read Exhibit 1 at all?
Right now? No, I didn't.
Did you read it when you got it?
Of course, yes.
And do you have a memory of whether or not we asked for all search warrants that were issued?
Do I remember now what's in the motion that you filed in December of 21? No, I don't.
Okay. Do you remember the motion asking for all documents, all turret tapes, all brick reports? Do you remember that?
objection.
What's that objection?
He either remembers or he doesn't.
My point is, it's been marked as an exhibit.
Yeah,
She took
it's in
it away from
evidence.
him, she's quizzing him on it,
Any event, you didn't realize that you had to turn over the search warrant until when, sir?
Until I was made aware of it after Ms. Hickman took over the case.
So sometime in 2025, you realized that you didn't turn over the search warrants?
Yes.
And at that point, does anyone go to you and say, why didn't you turn over the search warrants?
Objection.
Sustained.
Did you have a conversation with ADA Hickman regarding the search warrants?
Objection.
Yes or no?
Yes.
And did you indicate to her any reason why you wouldn't have turned over these search warrants?
Objection.
Sustained.
Judge, can I be heard on this?
Yes.
So, in addition to perhaps has a discovery practice from the district attorney's office with respect to this witness, I'm trying to establish that the office itself had no policies and no follow-up when discovery was disclosed late. And the only way I can do that is to ask him about the conversations he had with ADA Hickman, who's also going to be a witness in this case, Judge, about what happened. Because I'm assuming, and maybe I'm wrong, but I'm assuming that they would have had some conversation saying, how'd you miss it?
Okay. The objection is still sustained.
So you remember having a conversation with ADA Hickman, is that right?
Yes.
Were you shown the search warrant?
Objection.
I don't see the relevance of whether he was shown the search warrants in 2025. They were disclosed in 2025. The question is, what was his practice and why didn't he disclose them before? Right? Okay, go ahead.
So, did you have a practice within the Norfolk County District Attorney's Office of ensuring that you turn over search warrants?
I have a practice?
Did you personally have a practice?
No, not a
Because
practice.
the Norfolk County District Attorney's Office had a practice of making sure that search warrants that were generated out of the district courts were contained in the file and turned over to defense attorneys.
I mean, that would be the expectation, yes. I don't think it was a formal policy or a practice, but any discoverable material needs to be turned over.
Did you ever go to the Quincy District Court, sir, where these search warrants were generated, to get copies of them prior to their disclosure in 2025?
No, I did not.
But you knew they were issued out of the Quincy District Court, right?
That I did.
And you knew that they weren't contained in anything that you had turned over because you looked at everything you turned over, right?
So that would be the failing, is that I didn't realize that it hadn't already been turned over.
22 search warrants. Make sure that everything is okay. So, sir, were you then aware that there were another 4 search warrants that were issued in 2022?
Yes.
Did you have any participation in drafting the affidavits for those search warrants?
Drafting? No.
Who drafted the affidavits for those search warrants?
My memory would be Trooper Proctor.
Trooper Proctor drafted them?
I believe so, yeah.
When he finished drafting, does he send it to you and say, is this okay? Can we file it?
It might be forwarded to my attention for edits or things of that nature, but I wouldn't consider myself drafting it.
Okay. And can you just remind us, do you remember what date Myles King was arraigned?
In this court?
Yes.
Sometime in December of 2021.
Okay. And then you remember in January 2021, after the arraignment, seeking search warrants for information regarding Mr. King.
Regarding Mr. King? No, I don't believe so.
Relative to anything in this case?
Yes, I think it was more of a geofence that they were looking for.
And why were you looking for the geofence information in 2022 after Mr. King had been indicted?
To try to identify the person that was with Mr. King when he shot Mr. Simmons.
I'm sorry?
To try to identify the second party that was with Mr. King when he shot Mr. Simmons.
And did you bring your request for the search warrant to the Superior Court and ask for permission to file the search warrant after indictment?
I don't believe so, no.
Do you know whether or not you have an obligation to do that once a defendant is indicted and you want to file an additional search warrant and bring that to the attention of the Superior Court?
That is my practice, yes.
And did you do that in this case?
I didn't do anything in this case in reference to search warrants as far as bringing a search warrant.
Sorry?
I didn't bring any search warrants, so I don't recall where it was brought.
Are you saying that Trooper Proctor did this on his own, and you were unaware of it?
I'm not saying unaware. I'm saying as far as there was no, I was not involved in applying for search warrants.
Okay, so, but you knew they were happening, right?
Yes.
And so my question to you is, did you know that you had, do you believe you had any obligation to come before the Superior Court after Mr. King was arraigned to ask for permission to file additional search warrants?
Any obligation? No.
Did you come before any Superior Court and ask for permission to file additional search warrants in this case?
Did I? No.
Do you know if anyone from your office did?
I don't believe so, no.
Now, do you know whether or not after a defendant is indicted, whether it's still proper procedure to go to the district, if they're indicted in the Superior Court, to go to the district court to request additional search warrants? Is that proper procedure, sir?
It can be?
It can be.
Yes.
Okay. Do you believe there's any mechanism by which, once the defendant is arraigned in Superior Court, if you wanted to issue any additional search warrants, that a defendant has an opportunity to be heard?
No.
Judge, I'd move to introduce the search warrants numbered to, I think they start with 2-1, 2-2, 2-3, and 2-4. These, my copies are not base stamped. I don't know if the Congress going to have a problem with them, but you can look at those.
I never paid attention to it.
Okay, so need a copy of these, yeah. So can I put this around?
Yes.
These are the 2022 search warrants. Can you take a look at them and verify that we're talking about the same thing, please?
Appear to be, yes.
Those are the 2022 search warrants?
I believe so, yeah.
Okay. And in the 2022 search warrants, we were looking at information, Google information, is that right?
I believe so, yes.
Is that all you were looking for is Google information, or were there additional things you were looking for?
Google is what I recall.
Okay. So, you asked for information from T-Mobile, Sprint, AT&T, and Verizon, is that right?
That's my understanding, yes.
And those are all Google warrants relative to activities that took place on the day of the homicide, is that right?
Yes.
As I move to introduce the 2022 search warrant as the next exhibit.
Any objection?
No, Your Honor.
Exhibit 3.
Just want to make clear for the record, these are not geofence. I know I can bring this up on cross.
They are geofence. Okay.
They're not
They are not.
tower dumps.
Okay.
I was just going to get there, Judge.
Okay.
So, Attorney Lally, when you just reviewed these, your understanding of them is that they were geofence warrants, is that right?
No, they were tower dumps.
What's the difference between a geofence and a tower dump?
So a tower dump is essentially looking for any phone numbers that were hitting off a specific tower within a general geographic vicinity of a location that you're looking for, whereas a geofence is more, how I would describe it. It's a wider net, I would say, as far as capturing what devices or what. Well,
doesn't the geofence ask Google to give them all of the people who might have been in a specific area at a specific time?
Correct.
And the tower dumps ask for the phones that are bouncing off towers at certain time periods. Is that right?
Correct.
And so, as a result of these 2022 search warrants that were issued, do you recall receiving any data?
Yes.
What did you receive?
I mean, as far as what was the data?
You remember, I mean, you had to look at the data and said, hey, this works, this doesn't work, we need to do something, follow up, right?
We received the data was turned over to you, and then I believe it was Trooper Keith that wrote a report in relation to it essentially wasn't helpful information.
That the tower dumps weren't helpful?
Correct.
So that would be exculpatory to Mr. King, right?
Yes, which is why you got it.
Okay. So when do you believe you turned over the 2022 search warrants?
Whenever I received them.
When did you receive them?
I could not tell you.
Okay. Do you remember anything about the review of the data that was received from the search warrant? Did you yourself review it, or did you have an expert from the state police or the Milton Police review the data?
It was an expert from the state police that reviewed the data.
Okay, and that's the report that you were talking about?
Yes.
And you believe at some point you disclosed these search warrants to me right after you received them, is that right?
Yes.
And you would have received them right after they were issued, is that right?
I couldn't tell you
And if this is correct, they were issued in January of 2022, is that right?
if that's what it says.
Okay, folks, witness, Your Honor.
Yes.
Yes, January 13th.
So you would have disclosed them shortly after January 13th of 2022, right?
I don't know when I disclosed them. I disclosed them,
As soon as you got them, you reviewed them, and that same day, you put together a discovery notice and you sent it out to me, right?
that was my general practice, yes.
Did you not follow your general practice with the 2022 search warrants?
I may not have had a copy of them on January 13th, 2022.
So my question is, when did you get them? When did you get a copy?
I would have to look at the notice of discovery, but it would have been within a short time prior to me sending that to you.
Okay. And so if these were returned on January 18th and signed off by Trooper Proctor on January 21st, would you expect the discovery notice to include, the next discovery notice to include the 2022 search warrants?
If I had copies of them, yes, but I
How
couldn't.
long does it take for the police to give you search warrants when they execute them and get returned? Is there like a lag period there sometimes?
Is there a lag period? I don't know when I received them.
You don't know when you receive them?
No.
Would there be something in your file that tells you received search warrants on such and such a date?
Notation in the file? No.
No. Okay. And then let me ask you something else. Do you recall, was it your practice when you were working on this case to base stamp any of the discovery material?
No.
And did the Norfolk County District Attorney's Office have a practice of base stamping discovery material?
I would say some DAs do, some DAs don't.
But your practice was to not bait stamp, is that right?
It wasn't an affirmative choice, but no, I didn't bait stamp discovery.
Okay. And did you ever have any trainings on how helpful bait stamping discovery is within the Norfolk County District Attorney's Office?
No.
Okay. In your practice of not bait stamping discovery, are you relying solely on the discovery notices that you produced to me to determine what information you turned over?
No, I mean, it would be, the notice of discovery would be what information has been turned over, and then if there was, obviously, whatever information is in the file.
So I guess, I don't think I followed that. So my question to you is the way that you keep track of discovery in this case, the notices of discovery that you sent to me?
Yes.
And in addition to those notices, there wasn't, as far as you were understanding, any other discovery out there, right?
Correct.
Okay. Now, you remember an individual, give me the Turner stuff. You remember an individual by the name of Turner, right?
Yes.
And who was Mr. Turner in this case? What role did he play?
Mr. Turner was an individual who was identified on a Ring camera who was providing CPR to Mr. Simmons.
So he was there at the time that Mr. Simmons, well, he's one of the people that were there at the time that Mr. Simmons was receiving aid, is that right?
Yes.
And he was at the head of Mr. Simmons' body, is that right?
I don't know if he was at the head of the chest, but he was in, yes.
Okay. And was he a black or white individual?
Black, I believe.
Okay. And when's the first time you heard the name Turner in the course of this investigation? Do you recall?
At some point, it took a bit of time, I believe, to identify. He didn't stay on scene, so it took a bit of time for us to establish his identity from talking to people around the neighborhood, and then I was given a name and I summoned him to grand jury.
When you were talking to people around the neighborhood, were you showing them a photograph of Mr. Turner?
To be clear, I was not walking around and talking to people in the neighborhood. Investigators were, and I believe that's what they were doing, is showing a photograph.
Yes.
Can you review this document and tell me whether or not you recognize it?
recognize what it is, but I don't recognize it in that I haven't seen it before.
You've never seen that document before?
Nope.
And what do you recognize it to be, sir?
It appears to be a photograph of Mr. Turner from the video.
And you didn't know that back on July 27th of 2021, that the police department had a photograph of Mr. Turner, who was the person who was at the victim's head at the time that the police and the ambulance showed up? Did you know that?
I knew that there was obviously video depicting that, but I didn't know that there was a photograph and a posted notice in regard to it.
So the police never told you they were showing a photograph around the neighborhood of who they thought might have been Mr. Turner to see if anyone could identify him because he was at Mr. Simmons' head when the police came and the ambulance came?
Not that I recall, and this is the one report that I was referencing earlier as far as the report that I didn't receive.
This is from the Milton Police Department?
Yes.
Did you guys have any conversations with anyone from the Milton Department regarding Mr. Turner?
As far as, yes, as I mentioned, they were able to identify him. We had an address. We summoned him to the grand jury.
Did you ever speak to a Sergeant Clifton Murphy regarding Mr. Turner?
Regarding Mr. Turner, not that I can recall, no.
Sorry?
No, I don't believe I talked to her about... I believe he would have been the one to give me Mr. Turner's information so I could issue him the summons.
What about Milton Detective Mr. Similodoro?
Not that I can recall specifically in relation to Mr. Turner, no.
Okay. So, when did you become aware of this photograph? So first of all, let me introduce it. A copy of the court as well.
Any objection? No, Your Honor. All right. Let's see. Are we on number 4?
That's a copy of what I'm introducing.
Oh, I thought you had a photo.
I thought you.
Oh, okay.
May I see the document, please?
Sure. I have an extra copy, Judge. Here you go. Thank you. Sure.
All right, thank you.
So, Attorney Lally, when's the first time you became aware that either the Milton Police or the State Police were showing photographs of what they thought was Mr. Turner to individuals in the neighborhood?
In 2025.
When in 2025, sir?
I don't know.
Did anyone ever report back to you that they had a photograph of Mr. Turner?
No.
And you understood how important Mr. Turner was, right, to the defense?
Potentially.
Okay, because Mr. Turner was there when this alleged statement, Mizzy Cass did it, was supposed to have been said, right?
No.
I'm sorry?
No.
I'm sorry, was there an objection?
Yes.
No, I overrule the objection.
What's the answer?
No, that's not my understanding.
What is your, well, you said you didn't know anything about the photograph of Mr. Turner, so now you know he wasn't there?
No. You asked me whether or not I knew that Mr. Turner was there when the statement was made. I don't know that. When the statement was made, it was made to Officer Colligan, who was leaning into Mr. Simmons as he lay on the ground. I don't know that Mr. Turner was there because Mr. Turner was gone prior to the officers arriving there. That's why they didn't identify him initially.
Well, they
So my
did
assumption
describe
would
him,
be
right?
that Mr. Turner wasn't there.
Stop. The officers described Mr. Turner, right?
No, I think they
The officers
described
described Mr. Turner. They described him as a heavy-set black man, right?
that they observed in the video, yes. I don't think they observed him on scene.
Well, you never asked them, hey, do you know if Turner heard that statement? This was Mizzy Cash?
Did I ask them whether or not they knew that Mr. Turner had overheard or not? No, I
Did
did
you
not.
ever send them out to say, hey, go find Mr. Turner and see whether or not he overheard the statement attributed to the victim saying that Mizzy Cash killed him?
That's why we were looking for Mr. Turner.
Okay. So the photograph that you became aware of in 2025, when was it generated? Do you know?
I don't.
Did you, so somebody else did this without your knowledge? Is that what happened?
Not without my knowledge. As far as my knowledge was, that there were two individuals on the ring camera. One, we knew who it was, and the other person, I wanted to know who it was so that we could bring them into grand jury and find out what they knew, whether or not they had witnessed the shooting itself, overheard the statements, had any information inculpatory or exculpatory to provide.
Okay. And when you found out in 2025 that there was this photo being generated, did you have any conversations with anyone in the Norfolk County District Attorney's Office about that photo?
Yes.
Who'd you have a conversation with?
Probably be Ms. Hickman.
Attorney Hickman?
Yes.
Okay. And did you ever get to the bottom of why you weren't provided with a photograph of an individual who may have been an eyewitness to this crime?
No.
Overruled.
I'm sorry, what was the answer?
No, was the answer.
I didn't hear it, Judge, that's why I asked.
Okay, no problem.
Now, you understand that before the information was disclosed to me in 2025, Mr. Turner passed away, right?
That's my understanding, yes.
So the defense would have never had an opportunity to find him and interview him.
Objection.
We didn't.
There was an objection.
Okay.
Well, I mean, let me just understand. Having read the papers, my understanding was that Turner was brought to the grand jury
I'm getting there, Judge.
and invoked,
Yes.
right? So I assume that the grand jury minutes were disclosed. So the predicate for your question is, you know, maybe it's several steps away. Maybe the grand jury minutes involving Mr. Turner were never disclosed to you. I don't know, but let's get there.
Okay. So, was Mr. Turner ever summoned to the grand jury?
He was.
And how'd you find him?
Again, I was given the information from Lieutenant Collins as far as his name, address, and sent him a summons.
Where did you summon him? Do you remember?
I don't.
Okay. When he got to the grand jury, sir, did he testify in front of the grand jury?
He did not.
Why not?
He had indicated prior to the day of his testimony that he wished to speak to an attorney. In regard to a fifth, we arranged for that as far as the duty attorney of the day to speak with Mr. Turner. That was obviously done outside of my presence. Then the practice would be if the attorney believes that there is a Fifth Amendment privilege to bring him over to this courthouse in front of a judge where he can assert that privilege on the record.
And did that happen with Mr. Turner? Did Mr. Turner get brought before a judge to assert a privilege?
Yes, I believe it was an in-camera hearing before Judge Cosgrove over in 25. I wasn't obviously present for whatever the fifth was, but I was informed that he had a valid fifth and he was asserting it.
And the information regarding Mr. Turner taking the fifth, when was that turned over to Mr. King?
I don't think it was.
You don't think it was?
No.
Why not?
I don't have a good explanation for that other than it was never asked for and it's not really a statement by him. I don't know that it's discoverable under Rule 14.
You don't know the witness who could potentially be an eyewitness to the crime, shows up at the grand jury and takes the fifth. You don't know if that's discoverable to the defendant? Is that what you just said?
No, as far as the statement, there's no statement there's nothing as far as what Mr. Turner said that I'm privy to.
But the fact that he's taking the fifth, that he thinks he has an issue of self-incrimination, do you not believe that would have been exculpatory to Mr. King?
I think it's something that should have been turned over, yes.
So why didn't you turn it over?
I don't have an explanation for that.
All right. With respect to...
Was anything relating to Mr. Turner's identity turned over to the defense prior to 2025?
Upon my subsequent review, no. Did I believe that it had been prior to 2025? That was my belief, but that was a mistaken belief.
And what is it that you believed was turned over with respect to Mr. Turner?
I thought that he was referenced not only, well, he's, as far as the video that he's depicted in was turned over, but as far as his identity, I was under the impression it was contained within the Milton reports that have been provided to counsel.
Okay.
And you found out it wasn't contained within the Milton reports that you provided me, is that right?
That's right.
That it wasn't disclosed to me till Attorney Hickman got involved in the case in 2025, is that right?
Objection.
I think it's already determined that it wasn't turned over until 2025, at least according to this witness.
Okay. So, photograph of Mr. Turner, do you know if it was generated from brick? The brick, do you know what the brick is?
I know what the brick is, yes.
What's the brick? Tell us what.
It's a intelligence gathering database of the Boston Police Department.
Is it the gang database of the Boston Police Department?
I don't think it's exclusively a gang database, but it is used to identify gang members, yes.
Okay. And do you see reference to the brick on the photograph that we believe is Mr. Turner on the bottom right-hand corner?
And there's reference to the brick? I don't know.
Yeah, I see. Do you see that word on that photo?
I see the word, but I don't know that this was generated. It was distributed by the brick, but I don't know that it was generated by the brick.
Okay. Did you have any idea when you represented the Commonwealth in 2025 that there was some reference to brick and Mr. Turner in a photograph that was possessed by the Milton Police Department but not turned over to me?
No. Had I been, you would have had it.
Okay. Was the brick a part of this investigation as far as you understood?
No.
So how did the brick end up on this flyer saying, if you have any information, please be advised, contact Trooper Proctor, Milton Police Detective Similidoro, or the brick? How did that end up there?
I don't know.
Do you know whether or not Mr. Turner has any brick entries?
I don't.
Do you remember who Mr. Turner's attorney was?
No.
Were you told at all what the substance of the Fifth Amendment privilege was of Mr. Turner?
No.
But you believe that a judge in the Superior Court found a valid Fifth Amendment privilege that disqualified him as having to respond to the grand jury subpoena, is that right?
Correct.
Now, you remember there being some, what's the camera? Ring camera? Ring camera video in this case. Do you remember that?
Yes.
And do you remember the ring camera video with the two kids, one in a red sweatsuit, one in a green sweatsuit, that were seen, according to the witnesses in the 911, somewhere near the crime scene? Do you remember that?
Objection.
Overruled. I don't recall that in reference to a ring video.
Okay. Do you remember anyone putting in some ring camera at the grand jury? Was that you?
Yes.
And do you remember the ring camera showing kids walking down the street? One in a green sweatshirt, one in a green sweatsuit, one in a red sweatsuit.
No.
Nick, do you have that? Do you remember at all whether or not it was represented to you that what you were introducing at the grand jury with respect to this ring camera was the entirety of the ring camera? Is that what you understood when you were introducing it to the grand jury?
Yes.
Did you ever learn that it actually wasn't the entirety of the ring camera, that there were other things on the ring camera that weren't turned over, either to you or to me?
Objection to form of the question. I'm just trying to understand what.
It's compound, and I'll ask you to just break it down.
Sure. The ring camera that you introduced at the grand jury in the case against Mr. King, did you understand that to be the full ring video that police officers generated or seized as a result of this case, right?
Yes.
No one told you they edited it in any way, right?
No.
And if it was edited, you would have introduced the whole thing, right?
Correct.
Okay. And did you ever learn in the course of your representing the Commonwealth in this case that what you introduced in front of the grand jury wasn't the entire ring camera?
Did I ever learn that? No.
Are you just finding out about this for the first time today?
Right now.
Okay. And if I told you that ring camera had an individual dressed in a green sweatsuit and an individual dressed in a red sweatsuit walking in the area of the crime at the time, would that have been something you'd sent your officers out to investigate?
Yes.
And did you do that in this case, sir?
Did I send them out to investigate something I wasn't aware of? No.
Can you think of any reason why a police officer would edit a ring camera before sending it to the grand jury?
Objection.
Overruled.
Can I think of a reason? Sure. I mean, length, things of that nature. But if there's a video that's going to be introduced as an exhibit before the grand jury, I might, if I'm presenting the case, I'm going to introduce the entirety of the video. I might also introduce as a separate exhibit a smaller snippet or portion of it, but the entire video would be admitted as an exhibit.
And that was your practice back when you indicted Mr. King, right?
It's always been my practice.
So you introduce the entire video, and then if you want the grand jurors to focus on a certain portion of the video, you do a clip and you introduce that as a separate exhibit, right?
Correct.
And in this case, you introduced a ring video that was given to you by who? Who gave you the ring video? Do you remember?
Specifically, no, but my assumption would be Trooper Proctor.
Okay. And did anyone ever ask you to look at that ring camera video that you introduced at the grand jury and look at the full ring camera video before you testified here today?
No, up until right now, I thought that the video was the full video.
Can I just ask, the ring camera video that we're referring to, where was it shot from and what area did it depict?
The one that, if I'm correct in what Ms. Scapicchio was talking about, would be depicting sort of the front area of Mr. Simmons' home where he was found, where he was being treated by Mr. Carter and Mr. Turner, if I'm correct in what she's referring to. Okay.
And that's where first responders responded?
Yes.
Okay. And did that ring camera video, as it was provided to you, depict Mr. Turner?
Yes.
And did it also depict the first responders arriving?
Yes.
And did it depict that Mr. Turner was on scene when the first responders were arriving?
He's not visible on camera when the first responders arrived.
Okay. Go ahead.
Thank you.
May I clean something up here, Your Honor? I know I can do this on cross.
I can't hear him. I'm sorry, what?
Could I just clean something up here?
Just have a conversation with Attorney Scapicchio.
Explain to him. Put this in. The new one that you got. Just mark it. If you want to ask him about it, you can, but.
He hasn't seen that. Is that what you're saying?
He hasn't seen it.
Okay. I'll have to put it in.
May I explain it to the court? So, just to explain this out, grand jury exhibit number 21 was a 2-minute and 1-second clip. It was provided in Notice of Discovery 1, number 46. The time on the clip is 18:08:31 Eastern Standard Time. The second video that the witness is not aware of, and I have in my hand, and I'd be happy to mark it as, or counsel can mark as an exhibit, is a ring video provided on May 15th of 2025. It is 10 seconds in length from the same residence, and the time on the video is 16:59:47 Eastern Standard Time. This is noted in Discovery 31, date stamp 002026. And just so Your Honor is aware of the timing on this, the first 911 call came in.
That's notice of discovery, what, did you say 30-something?
31.
31, and it was what?
Date stamp 2026.
Okay.
So the second product, this ring thumb drive, is 1 hour prior to the homicide.
The 10-second clip?
So this is the full video, Judge.
That's the full, I thought you said it was 10 seconds.
It's a 10-second clip that was provided on May 15th of 2025 by A.D.A. Hickman.
Your Honor, let me clarify, that produced it. It has on it is the grand jury exhibit, which is a 2-minute and 10-second one, as well as the 10-second clip that I produced as well. So both clips are on it.
Excellent.
May I introduce the judge?
I thought you were referring to a ring camera video that was the original source, if you will, of the 2-minute and 1 second clip, which is Grand Jury Exhibit 21. I'm sorry?
It's the same exact house.
Your Honor, it's not an hour, it's a 10-second clip about over 1 hour prior to the homicide.
I understand that those are the two clips you're talking about,
Yes.
but I understood Attorney Scapiccio's questioning to be suggesting that the 2-minute and 1 second clip was a subset of a much longer ring camera video that was obtained by the police at the time that they collected ring camera from
I
that
believe it was,
location.
Judge.
Okay.
I believe that this video is prior to and the day of, or the hour of the...
Yeah, but it's 10 seconds. It's not a subset, or it's not a greater set out of which the 2-minute and 1 second clip was taken.
No, Judge, because it comes from the same exact home, the same exact ring camera. What they introduced in front of the grand jury was this clip of what happened when Mr. Simmons was shot. What they had and didn't introduce, in my opinion, is what happened right before Mr. Simmons was shot. Who was in the area before Mr. Simmons was shot? And it's important to us, Judge, because there was a description.
Before you start arguing your closing, okay?
I'm not trying to do my closing, Judge. I'm tell you why it's important.
I understand. They may have had a clip of 10 seconds before, an hour before this incident, an hour before the 2-minute clip that was introduced in front of the grand jury. That's a different animal. That's different than what you were suggesting in your questioning, which was that the 2-minute and 1 second clip was a subset of a much longer clip that encompassed the 2-minute and 1 second clip introduced to the grand jury.
And that's what I believe happened. They're saying it's two separate...
Do you have the longer clip that the 2-minute and 1 second clip was a subset of?
Well, I have the two clips, Judge. It's a continuation of the same view from the same camera.
But
so what got introduced
is there any evidence that the police or anybody investigating this case had the whole ring camera video from whatever time, 1659 through 1810?
There's an email, Judge, which purports to be from an individual who's trying to contact the district attorney's office about ring camera. It was Mr. Proctor's job to collect the ring camera. There is an email suggesting that this individual had 2 ring cameras available for collection. I don't know what on earth Trooper Proctor would go and get 1 ring camera and leave the other ring camera and not look at it at all, Judge. I don't know. I plan on asking him that when he takes the witness stand.
Your Honor, if I could just clarify for the record, an email was accompanied with the second ring video that was produced on the 2066, I believe is the base stamp. There was an email that was dated and it's base stamp 2016, about this separate 10-second clip that was also forwarded by the residents of that home to the Milton police. That is the 10-second clip that occurred 1 hour prior to the homicide. No video of one continuous has been inferred by Ms. Scapicchio that 2-minute, 10-second was somehow edited out from a 1-hour video. There was a 10-second clip that the homeowner in that email that was provided to defense counsel say, I found this too, that was provided from that same residence, and then the 2-minute and 10-second video that was from that residence that was put into the grand jury. There is no 1-hour video that anything has been edited out to, and the email where that 10-second clip came from was provided to Attorney Scapicchio explaining where that came from.
Is there a state police memo by Trooper Proctor that says, on such and such a day, I went to such and such a location, looked at their Ring camera video, the only relevant section was this 2-minute and 1-second clip, or describing when and how Trooper Proctor got the video?
Trooper Proctor, my understanding is not the one who got the video on it.
Okay.
This came into the Milton Police Department. There is not a report. It was provided by the homeowner, the 2-minute and 10-second, and then the homeowner determined that there was a second clip that was approximately 1 hour prior to the homicide, which is what was produced when I took the case over, when I found that email.
But nobody actually went to the home to look at the video to see whether there was anything relevant on the Ring camera?
I don't believe so, Your Honor.
Okay.
So, Judge, my understanding, just so my position is clear, my understanding is the same homeowner sent 2 videos or disclosed that 2 videos existed.
What's your basis for that understanding?
Because there's an email that says, here's the 2 videos.
2 different video clips, relevant clips, or 2 different video angles from 2 different Ring cameras?
The same Ring camera, Judge.
One Ring camera.
On the house.
Okay.
So there's an email that suggests, Judge, that's dated July 11th of 2021, that suggests this is a Ring camera, and that they were forwarding this to the Milton Police Department. Now, what gets introduced in front of the grand jury is one of those 2 Ring cameras, and I believe it's represented that it's all of the Ring cameras that they have, and then I find out sometime in 2026, it's not all of the Ring cameras that they have, and that the second Ring camera that got disclosed in 25 or 26, I'm losing track of all the late discovery here, but when it gets disclosed, Judge, I realize when I look at it that the video that is prior to the incident shows 2 individuals who were described on the 911 tape, one having a red sweatsuit, one having a green sweatsuit. They're walking by the house that has this video, and one of the individuals keeps looking back, as if he's looking back or looking for somebody, which becomes exculpatory to me to be able to look that up, Judge. And I'm just trying to figure out, if you got 2 videos, why'd you only introduce one, and why didn't you tell me there were 2? That's all I'm trying to establish, Judge.
Okay, go ahead.
We marked the 2 videos.
Any objection to marking the 2 videos?
Not at all.
Okay, are they on a single thumb drive or 2 different thumb drives? Single thumb drive, okay, by agreement. Exhibit 5 will be the thumb drive.
Thank you. So, Attorney Lally, had you known that the homeowner had sent 2 videos to either the Milton Police or the State Police, whoever it was, would you have introduced both videos in front of the grand jury?
Yes.
And would you have turned both videos over to me in 2021?
Yes, of course.
Now, can I just have a minute, Your Honor?
Sure.
Okay. So, the last thing I want to talk to you regarding the late discovery aspect of this is your 2025 grand jury testimony regarding Mr. King's jail calls. Do you remember that?
Grand jury testimony?
Well, let me put it this way. Sometime in 2025, after Mr. King was indicted, did you go in front of a separate grand jury asking them to return the jail calls of Mr. King because they'd never been returned?
To make the return of the jail calls, yes.
But that wasn't the grand jury that indicted Mr. King, right?
Correct.
And you presented evidence to a separate grand jury, right?
Yes.
After his indictment, right?
Yes.
And you indicated to them that it was just a formality, right? That the grand jury never actually returned the jail calls, so you couldn't introduce them at trial. You needed a separate grand jury to return the information regarding the jail calls. Is that right?
I don't think I put it that way. Essentially, so because the jail calls were subpoenaed pursuant to the power of the grand jury, anything like that has to be returned to the grand jury. That's how we obtained them. We obtained them back in 2021.
And I guess they didn't go before the grand jury in 2021. Is that what happened?
No.
They got returned to a police officer. Is that what happened?
I'm sorry, they got returned to a police officer?
Right. In other words, Trooper Proctor had them, right?
Trooper Proctor had the Norfolk ones, I had the Plymouth ones.
Okay. So there were two sets of jail calls from Mr. King. There were Plymouth ones and Norfolk ones.
Correct.
Trooper Proctor had which one?
Norfolk.
And you had the Plymouth one?
Yes, because the Plymouth ones came in prior to us getting the Norfolk ones. I think we only got the Norfolk ones a week before the indictments were returned.
Okay. In any event, you go in front of a separate grand jury in 2025. What was your authority to go before a separate grand jury in 2025 to return jail calls that had been subpoenaed by a grand jury in 2021?
Again, so anything subpoenaed pursuant to the power of the grand jury has to be returned to the grand jury. It doesn't have to be the same grand jury that heard the case. Wasn't asking this grand jury to vote on anything. There was no presentation of any indictments or anything of that sort. It was just a process by which they have to be returned to a grand jury, whether it's jail calls, medical records, business records, anything that's summoned pursuant to the power of the grand jury has to be returned to the grand jury.
Did you notify the court that you were going in front of a separate grand jury to try to get these jail calls certified so you could use them at trial?
First of all, I wasn't. They were already certified, so I wasn't trying to get them certified, and I had no intention of using them at trial because there's nothing of any relevance on them.
And President Trump?
Yes.
Is this your grand jury presentation on January 28th of 2025 regarding Mr. King's jail calls?
Yes, those are the minutes.
Okay, without objection, Exhibit 6.
No objection. I may move to impound those afterwards because they're grand jury minutes.
Doesn't matter if you're
I move to impound. That particular exhibit.
There's no testimony, right?
It's just A.J. Lally telling the grand jurors that he needs them to return these jail calls because he needs them to be able to introduce them at trial. That's all.
All right. What's the reason for impoundment?
I didn't have.
I'll file a motion. She can move on right now.
I'm sorry?
Council can move forward. I'll file a motion.
All right, Exhibit 6 will be admitted.
So, thank you, Ron. So do you know whether or not Trooper Proctor ever had access to Mr. King's jail calls from Plymouth County?
I don't.
I'm sorry?
I don't know if he did or he didn't.
Okay. Did you ever review in the course of the discovery before you disclose them to me, Trooper Proctor's notes?
I'm sorry?
Trooper Proctor's notes, his handwritten notes. Did you ever?
Notes with regard to the Plymouth jail calls or something else?
These are the jail calls.
Okay. What exactly was the question?
Did he know?
Did Proctor know? Did Lally?
Did Lally know? Did Lally know? Okay. Did he review this? That's exactly what I'm going to ask him. So can I approach?
Yes.
Your Honor, may we have a second? Council's reviewing it.
Sure.
PDA Hickman's reviewing it for a second before she asks a question. Thank you. No objection. Do you need it?
That's your copy if you want.
Thank you very much.
Sure. You have a chance to do that, print out?
Yeah, it's a little hard to read, but based on the penmanship, but no. I have no idea.
You don't know what it is?
I don't know what his handwriting looks like. It appears to be notes. I've never seen that before.
You've never seen the notes before?
No.
So during the time period that you represented the Commonwealth, you didn't know that Trooper Proctor had notes of listening to jail calls from Mr. King before there was a return on those in front of a grand jury?
No, I didn't.
Okay. And with respect to the the notes, do you see anywhere in these notes references to Mr. King's social media account with passwords?
I mean, I see the word password.
Does it appear to be connected to an account of Mr. King?
It could be.
You know what you sit here today, Attorney Lally, when it was that prosecution became aware of Mr. King's passwords and usernames for social media?
Do I know? No.
Do you know?
I'm sorry, I couldn't hear you.
Sure. Do you know, as you sit here today, when the Commonwealth became aware that somebody in the police department had access to the jail calls and was taking note of Mr. King's social media accounts, usernames, and passwords?
Objection, just, 2 questions there.
Fair enough. Can you break it down?
Sure. Do you know whether or not anyone from the Commonwealth understood that a police officer was listening to Mr. King's jail calls and being apprised of Mr. King's social media accounts? Do you know that?
I don't know anything about that, no.
And also being apprised of usernames and passwords to Mr. King, because he was talking about them on a recorded line from the jail, right?
And that's what you're saying? Do I know anything about that? No.
So did any officer ever tell you that they were listening to the jail calls of Mr. King before there was ever even a return on Mr. King's phone calls?
So there was a separate trooper, Gendron, who listened to the bulk of the Norfolk calls prior to the return of the grand jury.
And what about the Plymouth calls?
The Plymouth calls, I had listened to the entirety of those 170 calls.
I'm sorry?
I listened to the 170 calls from Plymouth.
And when you listened to the 170 calls, there wasn't any information that was inculpatory to Mr. King, is that right?
Inculpatory, exculpatory, really anything relevant.
Okay. And in terms of, what was that exhibit?
Are you looking to introduce these notes? All right, we'll take them and mark them without objection, is that right? Okay, Exhibit 7 will be the notes.
I might need somebody else's copy because mine has highlights on them, and I don't want to introduce the highlights. Okay.
Features at 429.
This is big stamp at 429. Now,
Attorney Scapicchio, how much more do you have?
I was just getting into, and I was going to ask the court for permission to get into some of the text, emails, and voicemails of Trooper Proctor with this witness, Judge.
Okay, so that's the last of what you've got?
That's the last section of what I have here.
All right, so why don't we take our break now?
Sure.
We'll come back at 20 after 11 and reconvene, okay?
Thank you.
Court, all right?
Yeah.
Mr. King, want to bring it back?
Sure, will you move?
You're going to go back to that, okay? During the break, no, right now.
You are to vote back on the record in the matter of the Commonwealth versus King.
Okay, Mr. Lally, I'll just remind you, you're still under oath, okay? Yes.
Hey, Your Honor.
You may.
I was going over my notes at the break, Judge. There is one more additional
Go ahead.
exhibit that I want to introduce before we move on to the Proctor materials, and that is, I think I provided the court this morning a hard copy of the transcripts of the individual hearings in this case that we had transcribed. I've provided a copy of it to the district attorney's office, and I just want to move to introduce them to the court.
You want to introduce all the various prior transcripts of hearings?
Yes.
It's about 3 inches of paper. I left it all in my office. Maybe it's 2 inches of paper. I don't know.
It's also an electronic copy. The court has to give a paper copy so we have something.
Yeah, great.
I can provide another paper copy.
No. I have it in my office. I mean, it's not like I've highlighted them. They're sitting there. They should be on the round table in my office, Tim. Thank you. They're all transcripts.
I have a few questions about those transcripts, Judge, and then I'll move on to the process.
Okay, we'll see if we can get them in. Why don't you go on and we can come back to this.
So, Attorney Lally, we had a number of discovery conferences in this case. Is that right?
A few, yes.
Okay. And do you remember at various times during discovery representing to the court that discovery was either complete or almost complete?
I don't believe I represented it was complete, but almost complete would be accurate at different times, yeah.
Okay. And when you said discovery was almost complete back in 2020, I think it was 2, was that based on your understanding that you had everything that the Milton police had and everything that the state police had because you were relying on them to give it to you?
Objection.
I do think we've covered it, but I'll give you a little leeway.
Thank you. Is that why you were representing to the court that discovery was complete or almost complete?
If I was representing it to the court, then that was based on my understanding. Yes, is that I had asked for.
And you made those representations based on your understanding that you asked for everything and you assumed you got everything. Is that right?
These questions assume that he remembers what happened at something in 2022 that Your Honor has right in front of you.
Yeah.
I think there's a.
And it's it's lots of different hearings, so lots of different statements. It's a generalization question. I appreciate the problems with that.
So don't answer the questions I was saying?
The question.
It's mindset, Judge. I think it's state of mind. It's important to understand the discovery disclosure delays in this case, Judge.
Right, but we've covered that. That is to say that, he passed things on when he got it. He was relying on others to review the files in Milton and the state police. And if he noticed something was missing, he would ask them. But, basically he was relying on them to give him everything that they had. So I get that picture.
Fine, Your Honor, I'll move on. So the next set of questions, Judge, has to do with the Proctor audios, the Proctor text, and the Proctor photos and emails. I just want to alert the court, and I'm sure you already know, that some of this information is pretty offensive to the Black and brown community. I would never use the words that Super Proctor used, but in the initial videos that the audios that we want to play, Judge, the words are used, and we couldn't find a way to redact them out.
I have the material in your papers, right?
The audios I don't believe you have, Judge.
Are you looking to introduce them?
Yes.
Is there any indication that this witness has ever heard them? in the context of his work on this case?
That's the whole point, Judge.
He never did. So you can ask him.
Judge, the point is, the Commonwealth has made the claim in their opposition to the motion to dismiss that Trooper Proctor's opinions about black and brown people would not have affected his ability to properly investigate this case. And to the extent that that's the Commonwealth's argument, I want to ask this witness, who had the case for years.
I don't think that's their argument. I think their argument is it shouldn't justify dismissal of the indictment. Their argument is, but leaving aside that argument, this witness can only provide very limited evidence, if any, relevant to this particular question. So if you have a foundational question you want to ask him, did you ever hear Trooper Proctor's personal cell phone, messages or WhatsApp messages? Did you ever read them or did you ever ask for them? You can ask that.
The point being, Judge, that the idea that Trooper Proctor left his bias at the courthouse door when he conducted this investigation is something that I have to probe in order to produce enough evidence to suggest that that's not possible. And this is the witness who was involved in the case on behalf of the Commonwealth for years. And I think I have a right to ask him whether or not these statements and videos, had he known about them, whether he did or didn't. Let's assume he didn't. Well,
let's assume the predicate. Let's not assume the conclusion. Okay, ask him the question, did he know about it? And then we'll confront the next question, what would you have done if, the hypothetical.
Right.
Okay, but go ahead. Why don't you ask him whether he had any knowledge whatsoever about any of this stuff when he was representing the Commonwealth in connection with the King matter.
Thank you. Attorney Lally, how long did you know Trooper Proctor before you were assigned to the King case?
Whenever I didn't know him prior to his assignment to the State Police Detective Unit. When he became assigned to that unit, I couldn't say.
Had you worked with him before the King case?
Not on a case, no.
Would you work with him on something that wasn't a case?
No, what I'm saying is there could have been a situation where I spoke with him in regard to a call from the organ bank or some issue with the medical examiner's office or some unattended death that wasn't a case or something like that. But as far as working with him on a case, I believe Mr. King's case would be the first.
Okay. And how often would you say you had interaction with former Trooper Proctor?
In relation to this case?
Yes.
As in relation to this case would be whatever days there were for grand jury, court dates if he was needed, but, might talk to him before or after a court date in regard to whatever was discussed as far as discovery, things of that nature, but that's pretty much it.
Were you aware of any of the biases in racist beliefs held by Trooper Proctor when he was investigating the King case?
No, that was never communicated to me or in front of me or anywhere near me.
And had you been aware of Trooper Proctor's biases and racism, would you allow him to continue to work on Mr. King's case?
So I think that assumes that that's my decision. What I would have done is alerted both my supervisors, his supervisors, and made a strong recommendation that he not continue.
You would continue to work with Trooper Proctor after he called black and brown people animals?
That is absolutely not what I just said. Okay. What I said is I don't determine who the state police assigns as a case officer to a case. What I would do, based on the abhorrent nature of those communications as I understand them, would be to alert both my supervisors within the DA's office, his supervisors within the state police, and strongly recommend that he not have anything to do with the King case or any other case.
Why is that?
Based on the nature of my understanding of what's contained, I haven't seen or heard them personally, but it's utterly unacceptable.
Do you believe that Trooper Proctor's opinions of black and brown people dehumanize them?
I don't see how you could see it any other way.
Overruled. That can stand.
You don't see how you could see it any other way?
Correct.
Would you agree that Trooper Proctor's opinions and racism is an expression of hostility towards the black and brown community?
Objection.
I'm not sure how his opinion matters. He's already said that what he would do if he was alerted to it, and that he had not been alerted to it.
So you're saying I can't have the question, Judge?
Correct. So I sustain the objection.
Just note my objection, Judge.
Okay.
So, are you aware, Attorney Lally, of the depth of the hatred that Trooper Proctor had for black and brown people?
Objection.
Is he currently aware?
Yes.
I don't understand the relevance of his current knowledge. So this objection is sustained.
If I might, Your Honor,
Sure.
I think a preliminary, you asked for foundational questions. I would ask perhaps when and what he is aware of.
Sure, it assumes a lot.
Opinions about the mindset of Trooper Proctor.
Sure.
So have you heard any of Trooper Proctor's voicemails that he left with his group of friends about the black and brown community?
No.
Judge, I'd like to play one of those voicemails.
He's never heard them.
Right.
So the objection sustained.
So, Judge, with respect to this witness, the Commonwealth is making a claim that, and it's my understanding of the claim, maybe you see it differently, the Commonwealth claim is that to the extent that Trooper Proctor's racism existed, that it didn't, my understanding of the argument is that it didn't impact his work information because it was only on his personal cell phone. I want to talk to this witness because I don't expect Trooper Proctor to ever take the witness stand, Judge, and we all know he probably won't, about those texts, Judge, so that they become part of the record and that there's an understanding of how vile and disgusting Trooper Proctor's texts are as it relates to the black and brown community. And I have to set it up this way, Judge, because I expect to call an expert who has reviewed the text, who has listened to the audio and the video and looked at the photographs, and would be able to render an opinion about whether or not any person would be capable with this type of explicit bias of doing an impartial investigation.
Okay.
Your Honor, the Commonwealth had indicated in its opposition to the second supplemental motion that it would stipulate to the admissibility.
Can you speak right into the microphone because I'm having difficulty hearing you, and so is Attorney Scapicchio.
Yes, Your Honor. Your Honor, the Commonwealth would stipulate to the admissibility of the productions of materials from Mr. Proctor's phone that were provided to defense counsel. I know defense had filed a copy of the thumb drive with the court, I believe, when the motion was filed, and the Commonwealth previously indicated it seems that this is important material for the court to look at, and rather than going through a chain of custody witnesses, I would suggest the parties could stipulate that the court could have that thumb drive with the two productions of materials the counsel was referring to review.
Okay.
That's fine, Judge, but are you saying that I can't go through them with this witness or any other witness?
Well, if they've seen them and if they had a choice about whether they were going to be turned over or something like that, if they knew about them in advance, that's one thing. But to ask somebody their opinion about text messages that they never had privy to when they were working on the case, in all due respect to Mr. Lally, I can look at them, and I'm not sure what his opinion now about them is going to add. And so he's not being offered as an expert on the effect of racist communications on somebody's work product. And so I think you've gotten from him everything that you can get from him.
Okay. So, Judge, there are...
You have the thumb drive? We can admit it.
I don't have the actual thumb drive, Judge. The thumb drive is actually part of the record here. What I'm trying to do is point you in a certain direction of photos, emails, and texts that I expect my expert is going to talk about. I don't know if you want me to wait until my expert takes the stand or whether or not you want me to introduce them now, Judge.
No, you don't have to introduce them now. You don't ever have to introduce them. It's totally up to you. But I don't think this is the witness to question about them.
All right. So
if you have any, do you have any other questions for this witness relating to the transcripts?
No, Judge. Let me ask my office.
Here are the transcripts that you were asking about that we've gotten back from my office. So
yes.
you want
so I move to introduce those, Judge.
You want to introduce them?
Yes,
As one package or individually?
one pass.
One package. Any objection?
No, Your Honor.
It looks like these are 20 transcripts of hearings that precede the beginning of the motion to dismiss hearing and the copy of the motion to dismiss hearing. So that's 21 transcripts by my count.
Yes, sir. I think the last one is day one on the motion to suppress hearing, the motion to dismiss hearing. And I would ask for permission, to get funds to transcribe this hearing as well, Judge. But if the court's ruling is that I cannot go through any of the Proctor materials with Attorney Lally, I don't have any additional questions.
Okay, cross-examination?
No, my objection.
May I have a moment?
Sure.
Good morning, ADA Lally.
Morning, sir.
Wanted to start with the arraignment through the indictment, and I'm just going to mark this first. Should have done this while I was up. This matter started in Quincy District Court, correct?
Correct.
Mark, this is the next exhibit number 9, it's the docket 2156, CR 1848. I don't need it to be published to the witness.
There's no objection to Exhibit 9?
There's no objection, Judge.
Very good. Okay.
Who was the defendant's first attorney?
I believe it was Attorney John Geary.
Okay. And what discovery did you provide to Attorney John Geary?
Would have been the warrant report.
The what reports?
So the arrest warrant report, I'm
Arrest
sorry.
warrant, okay.
So the arrest warrant report, likely any reports that were available at that time, and probably copies of the motions to impound the search warrants.
Your Honor, may I approach with the number of
Sure.
exhibits here?
Just show counsel, I just want to see if...
You just handed me.
Oh, okay, very good.
The first exhibit, Your Honor, is the chart that I talked about earlier. I'm just going to mark that for the record.
Any objection?
Yeah, Judge, I don't believe we agree with what's named here. I don't know if this is the one that we agree on or the one that's the common one.
Well, why don't you talk and see if it is or isn't? You're holding off on that?
That will be fine.
All right.
And then I'm going to mark notice of discovery 28.
I thought they were all marked as exhibits, the notices of discovery. Is that what I said?
I don't think we're up to Exhibit 9, and no notices of discovery have yet been marked. They are obviously in the record, but if you're looking to mark them, we'll mark them.
So paper number 81, notice of discovery 28. Paper number 97.
No, I'm sorry. I want to just make sure my notes are accurate. Notice of discovery 28 is paper what?
28.
Okay. Exhibit 10, all right.
And notice of discovery 31 is paper number 97, and that will be exhibit number 11. Exhibit 11. And the Commonwealth supplemental information for notice of discovery 28 and 31 which was paper number 133. That'll be exhibit number 12. Then I'm going to approach the witness with, I have 5 stapled pieces of documents. I'm going to have them identified.
Okay.
And mark that as one total exhibit.
All right, we'll see if the 5 pages come in.
AD Lally, I handed you 5 separate stapled documents. I want you to take your time and take a look at them. I know they're 5 years old.
Okay, sure.
Okay. First one, AD Lally, it's a custody report from Milton Police. What is that?
It is a custody report from Milton Police in relation to, and I'm sorry, I'm just looking for the date. So this is an arrest date of April of 2019. So this would have been the gun case that Mr. King had pending when the homicide occurred.
Judge, I don't know how this is relevant to the discovery of the data close in this case. It's a completely separate case.
I don't yet know either.
Was,
We haven't moved its admission yet. I don't know. Go ahead.
have you seen this before?
Yes.
Was this provided to Attorney Geary?
Yes, everything to do with both cases. I believe he was appointed on both cases. So everything was provided to Mr. Geary, as well as the third case.
Okay. If we could just explain that to the court. What do you mean by both cases?
So at the time that the homicide occurred, there was an active case in the Quincy District Court for stolen motor vehicle and a firearm. And I believe the defendant had an as-yet unarranged motor vehicle offense, suspended registration, something of that effect.
Who represented him on those cases?
So Mr. Geary was appointed to, I believe, all 3 matters, represented him up until, I'm not sure exactly when Ms. Scapicchio came in, but it was sometime shortly prior to arraignment in this court.
In this custody report, the first stapled document, you provided that to Attorney Geary?
Yes.
How do you know that?
Because I specifically recall the arraignment date in Quincy District Court. I copied everything that was in all 3 of the files and gave it to Mr. Geary.
Second document here, it's dated April 3rd, 2019, Milton Police Department report, incident number 2019-3342. What do you recognize that to be?
Okay, so this is the 2 separate narrative reports in relation to the firearm case.
And again, did you provide that to Attorney Geary?
Yes.
How do you know that?
Again, I copied everything in the file that day. I believe there was even ballistics and DNA that had been done on that case at that point already.
An application for criminal complaint. Do you recognize that document in all the pages?
Yes, so this would be the application for a criminal complaint for the homicide as well as the warrant arrest report that I was referencing earlier.
And did you provide that to Attorney Geary?
Yes.
Criminal complaint for docket number 2156 CR 1496.
Okay, so this document would be the complaint, application for complaint, and narrative report in relation to the motor vehicle offense that I was referencing before, which appears to be a possession of a false or stolen RMV document, misuse of a number plate, and window obstruction.
And did you provide that to Attorney Geary?
Yes.
And this final document, 2 citations, what do you recognize that to be?
Again, so those would be the citations associated with the docket you just handed me on the motor vehicle offense, and yes, I provided it to Attorney Geary.
be collectively marked as Exhibit 11?
I don't know how they're
I think we're up to 13. These are pre-indictment disclosures by this witness.
This is a matter of housekeeping. On the chart that we haven't agreed to, there was notations of provided to Geary, or provided to Attorney Geary, and I wanted to make sure, as a sequester, I wanted to mark those documents so that it's clear that they were.
All right. You still objecting?
Yeah.
Okay, these will be marked as the next item over your objection, Exhibit 13, I think we're up to.
Thank you. Handing you what's noted as paper number 3, Notice of Discovery 1.
Yes.
And this is your notice of discovery you filed?
Yes.
May it be marked as Exhibit 14?
No objection, Judge.
Okay, Exhibit 14.
If you could take a moment, maybe Lally, and just go through it. Are any of the items that I just showed you marked as Exhibit 13 noted on Notice of Discovery 1?
Yes, I believe so.
Where so?
Item number 22. I'm just inferring it references the Milton Incident Report starting with 2020, which would have been prior to this case occurring. I don't, the arrest report, the warrant arrest report, from this incident is contained in here. I think that's all I can.
So those would have been provided to Attorney Geary in Quincy District Court at some point?
Yes.
Those items you noted?
So there are items that were provided to Attorney Geary. There were items that were provided to Ms. Scapicchio. There were also items so when he was arraigned on the 2 separate cases. Ms. Scapicchio indicated that she wasn't going to represent him on the firearm case. There was a separate attorney on that. I gave both counsel copies of whatever was contained in the Notice of Discovery 1 in relation to each of those cases, just to cover my bases.
Was anything else provided in Quincy District Court that you recall?
The only thing I can recall, because I know I had discussed it with Attorney Geary, was the search warrants, and there were motions to impound. So because the search warrants were impounded due to the ongoing investigation, I didn't provide copies of the search warrants, but I did provide copies of the motions that we had filed.
Let's switch gears to the search warrants, and I want you to keep Notice of Discovery 1 up there. And if I could have them exhibit the search warrants.
We're talking about Exhibits 2 or 3?
I'm going to start with 2.
Okay.
Noting on Notice of Discovery 1, numbers 53 to 55, what did you provide to counsel?
Just so I can be clear, so this, what you've provided me that's been marked as Exhibit 14 is a Notice of Discovery 1 for the co-defendant. They would have been identical as far as discovery that's provided, but just so that's clear for the record. But as far as those items that you just listed, Exhibit number 53 was call detail records from the defendant's phone that we received pursuant to the search warrants. Item 54 are call detail records from a separate cell phone, which were provided to the defendant, one of the 2021 search warrants. And item number 55 is another 54 pages of call detail records from another cell phone that we received pursuant to the 2021 search warrants. They were all marked as grand jury exhibits as well.
Okay. And those three items, and I just want to be clear on what was provided. I'm handing you what's been marked as Exhibit 2.
Mm-hmm.
I want to go through this slowly for the court. So let's start with 53.
Okay.
On discovery notice form.
Mm-hmm.
What does that reference?
53 is a certified copy of T-Mobile call detail records for a specific phone number that ends in 6961.
And whose number is that?
The defendant's.
Okay. Do you know what search warrant that was in reference to?
I believe the first search warrant, 303, was for a ping, so that wouldn't be that. It would probably be the second search warrant, which was for the call detail records of the defendant. So 306, I want to say.
You want to take a look? Just confirm that.
I'm sorry. Yes.
So 21 SW 306 was for the defendant's cell phone?
Yes.
And what you provided was call detail records, cell site information, subscriber information for the defendant's phone?
Correct.
But not the actual return?
So the items returned, but not the actual return, correct.
Sorry. The return said that there was no return. If you could look at the search warrant. As of a certain date.
Correct, yes.
Okay. Number 50, or 21 SW 307. What did you provide there? If you could look at the notice of discovery.
Oh, I'm sorry. I'm just looking for the phone number associated with this one. I'm sorry.
Search warrant 307, that ends in 307, that relates to what cell phone number?
Yes.
That's what I was looking for, Your Honor.
Okay.
It's the number that ends in 5962.
5962, and
Off the top of my head, no.
I suggested it was the victim's phone. Would you?
I would agree with that, yes.
What did you provide with respect to 307?
So with respect to 307, it would have been all of the call detail records. That's what's listed as item number 54 on Notice of Discovery 1. There was also, the phone was actually recovered from Mr. Simmons' property at the Boston Medical Center, and an extraction was done on Mr. Simmons' phone. All of that was provided to counsel as well.
What did you provide with respect to 21 SW 329? Let's start with this. Who is 21 SW 329? Take a moment to look at it.
So this, I would say, was the call detail records for Mr. Jeanette.
Who's Mr. Jeanette?
So Mr. Jeanette was a person of interest early on in the investigation. As I indicated, there were two individuals that were sort of monitored on surveillance camera from the defendant's mother's barbershop on Columbus Ave. all the way up to pulling onto Belvoir Road where the homicide took place. The vehicle that the defendant was in was a distinctive black Mercedes with main plates. It turns onto Belvoir Road, I would say, about 20 seconds or so prior to the victim, Mr. Simmons, turning onto Belvoir Road on his scooter. That was observed on a Ring camera. And throughout that, there's a second individual who's present with Mr. King, according to video and recipient witnesses. It was believed at the time that Mr. Jeanette might have been that other person, as there was a relative of his who was the registered owner of the plates that were fixed to the vehicle. From the call detail records, we were able to ascertain that he was, at least his phone was not in the area of the shooting at the time that it occurred.
Okay. What did you provide counsel on notice of discovery one, if you could look at it, with respect to 21 SW 321?
So it would have been the call detail records that were obtained pursuant to the warrants. I believe there was portions of a couple of the search warrants affidavit related to, so yes, I'm sorry, number 24, copy of search warrant, that would be for Mr. Jeanette's, that's item number 24.
I could point you to numbers 53 through 55.
Sure.
What did you provide with respect to 21 SW 321?
So that would be the certified copy of T-Mobile call detail records for number ending in 0134. Sure.
And that would include call detail records, cell site information, and subscriber information for standard as well.
Correct.
Just so the court's understanding of it, could you, I have in front of you exhibit number 2 of these bait stand search warrants.
Mm-hmm.
Are you familiar, could you just take a look at 329, actually, start 347, and what is that?
This is search warrant 347?
Yes.
Part of exhibit 2.
Yes. Do you know what that is? Take your time to read it.
Yes, so 347 and 348 were anticipatory search warrants that were applied for to search the defendant's phone had it ever been recovered, which it wasn't.
Okay, let's slow that down. So what's
Sure.
the anticipatory search warrant?
So the arrest warrant for the defendant was still outstanding. The defendant, when he turned himself in on the warrant for the murder, came into the Milton Police Station, did not have a cell phone on his person. So we were still actively trying to locate his cell phone to assist with location information related to his whereabouts on the day of the homicide.
And for 347 and 348, so 21 SW 347 and 348, was the phone ever located?
The phone was never located. Black Mercedes was never located. So 347 and 348 were never executed.
I want you to take a look at these search warrants again.
Okay.
Counsel asked you why, counsel mentioned the search warrants.
Mm-hmm.
What was provided to counsel from the search warrants? And take your time with this, it's important. Exhibit 2. To the best of your knowledge in looking at discovery notice 1, what was provided to counsel?
So in relation to any information pertaining to the search warrants, or?
Pieces of it. Cover sheet, affidavit, return.
Sure.
What was provided to counsel, what was not provided? To the best of your knowledge. And review of the notice of discovery.
Sure. So to the best of my knowledge, in notice of discovery 1, item number 24, is a copy of search warrant affidavit for T-Mobile cell phone ending in 6961. Number 20.
Would that be a draft affidavit with respect to 21 SW 306? The defendant's phone number? that?
The draft affidavit?
In anticipation of this hearing?
No.
Do you know what was drafted about it, or why it was provided to council?
Well, it was provided to council because that's what I had at the time of the arraignment. And so, you know, one of the things that I had made a note to do was to get the rest of these search warrants. But that's what I had at the time, so that's what I provided. And I think that may have led to some of my confusion as to what had been provided or not. Item number 25 is a copy of search warrant affidavit, so the for T-Mobile cell phone ending in 6961.
You know which, that was also...
That's also the...
21 SW 306, correct?
Correct.
So you provided a draft and an affidavit?
Yes.
Was that the affidavit that was, that is in the 21 SW 306 marked as exhibit 2?
Yes.
You talked about 53 to 55. Were those also grand jury exhibits?
They were.
Okay. And what are those call detail records?
I'm sorry, what are they?
Yeah.
So they're records that we received from a cell phone service provider indicating different data sets related to a mobile phone as far as longitude, latitude, location, calls, text, duration, things of that nature. So it's not an extraction of the phone itself, it's more of just a record of the phone's activity.
First ask permission to mark notice of discovery 30, paper number 98.
Okay.
Say that again?
Notice of discovery number 30.
No, I have no objection.
Did we mark the 5 stapled documents as 13? Oh, this is 15. Okay. Okay, good, thanks.
Handed you 3 packets. ADA Lally, what are those to you?
So these are the call detail records that were marked as grand jury exhibits. In this matter, exhibits 33, 34, and 35.
Are those the items identified in notice of discovery lines 53 to 55?
Correct.
Notice of discovery 1.
Line 53 to 55.
So this is just a reproduction of the same things that were produced in 1? Is that right, Mr. Lally?
Yes.
Okay.
If these could be marked sequential.
I'm sorry, what are these?
The CDRs that you just identified as lines 53 to 55.
Or 33 to 35 in the grand jury? Okay.
This witness saying he has an actual memory today of these are the things that he put in front of the grand jury? Is that what he's saying?
I don't know what the question is. He's just asking them to be marked sequentially. Is there any objection to marking them?
I don't know what the relevance is, I guess.
I don't know the relevance either.
There's 2 points of relevance. One, these are CDRs for the phones of these search warrants that that some of the search warrants were not provided to council. So there's notice, so there's no surprise as to what was provided as the existence of these returns.
The fruits of the warrants were produced.
Correct.
Okay, but I think we've established that already. I'm not sure why we're putting the CDRs in. I'm not going to look at the CDRs, right?
The other relevance is housekeeping. These are the base stamp items that go to discovery notice 30 that have been provided into 2025. So this was not new. This was just provided in the abundance of caution by ADA.
Okay.
So there's 2 points of relevance.
According to them, yeah.
Is there a disagreement about that?
There is.
That you,
It's about whether or not Mr. Lally's discovery notices are actually reliable. And I have emails back and forth.
That's not the question. The question is whether these were previously produced, whether they were produced as part of Notice of Discovery 1. Either they were or they weren't. Do you say that they weren't produced?
Some of them were not, no.
What wasn't produced?
I have an email that went back and forth with Attorney Lally right after we got the discovery notice, Judge, where we first asked him to send us all the discovery of the case, and then he indicated that he sent us the discovery, and we went through it, and we identified the information that was in his discovery notice that wasn't actually in his production that he gave us, and we asked him to produce it.
So the question is, which of these 3 documents were not produced, or what part of it?
I don't know if he has a specific memory. My understanding from speaking to Attorney Hickman is that he has no memory of what he turned over. He kept no notes of what he turned over, and now he's sitting on the stand saying, these are the documents I turned over. And I have emails saying, wait, these are the things that you say you turned over, but you didn't turn over any of these. So where are they? That's where we are, Judge.
You can mark those 3 as the next sequential items. Do those relate to particular vendors?
Excuse me?
They relate to particular phone numbers or particular cell phone providers? Well, let's just identify them for the record.
Sure.
Exhibit 16 relates to what?
Exhibit 16 relates to 781308691.
6961, okay?
Exhibit 17 is 617.
Just the last 4 digits is all we need.
5962.
5962, okay, and 18?
0134.
0134, okay.
With respect to these exhibits, ADA Lally, what's significant about these that you recall, that, how do you know that these were produced to council in 2021?
Because I specifically copied all the discovery and gave it to council on the arraignment date.
How do you know that these specific documents that I've handed you and marked as exhibits are the, what was provided to council?
Because it's noted within the notice of discovery, but it's also, I copied the entire file and gave it to Ms. Scapicchio on the date of arraignment in Superior Court.
And if I could point you to the bottom right-hand corner of all 3 of those documents. What is on the bottom right-hand corner of all of those documents?
It's a copy of the grand jury sticker that's affixed to the originals that are in, presumably still within our file.
So these are the true and accurate copies of the grand jury exhibits?
Correct.
Okay. Thank you very much.
So this is what I wanted the parties to get together and figure out. Is it your contention, Attorney Scapicchio, that these exhibits, these grand jury exhibits were not produced?
Some of them were not produced, Judge, yeah.
Which of these 3 were not produced?
I don't know what he introduced, Judge, so I can't tell you right now. I'll have to look at it after today and respond to the court.
Okay.
In terms of my communication with Attorney Lally, every single solitary time.
No, I don't want generalization. I just want a simple answer to my question.
I guess I don't know.
You don't know.
I didn't know they were going to.
All right. You don't know.
I'm happy to look through them and let the court know, but I don't know as I sit here today.
Well, you went through all the notices of discovery, right? And including the new, the more recent ones, and you were going to make a comparison as to whether you had them or you didn't have them.
You did.
Okay, so there's some sort of a list that you came up with. Can you look at that list and see if you got these 3 documents?
I'm happy to do that.
Let's look at it.
I do have what.
I'm trying to figure out what we're fighting about and what we're not really fighting about.
So this is last, I printed this. What Nicole, you, as your last draft.
And this is the draft one. Okay.
Well, I know that is the draft that we agreed
That's what I was
after our
gonna put
last
in.
hearing, correct?
Hold on,
So you guys went through, and that is what I copied that.
hold on.
Scapicchio gave us.
Judge, I might need a little bit more time. This is, I think what I'm looking at is Discovery Notice 26, which I think incorporates some of Discovery Notice 1. Not sure if it incorporates all of Discovery 1. I don't want to waste the court's time. I'm happy to do this.
I have only a question about 3 documents,
I understand that, Judge.
right? Just these 3, which we're talking about now.
I understand that, Judge. And I'm trying to figure out, based on this Discovery Notice 26, that has different item numbers than the ones that they just talked about in Discovery Notice 1. And that's what the issue is.
Okay, do you know which item numbers in exhibit in the Notice of Discovery 26 these correspond to?
Excuse me?
Yes, the documents you just introduced, exhibit 16, 17, and 18. I'm trying to figure out if there's a dispute about these.
Yep.
These were reproduced, you say. They were produced, you say, in Notice of Discovery 1, and then again produced after...
Notice of Discovery 30, yes.
Oh, Notice of Discovery 30. Okay, which item in Notice of Discovery 30 do they correspond to? Go ahead.
Number 15.
Two 28, 229, and 230.
The grand jury exhibit 33, 34, and 34.
Okay?
As previously provided,
In Notice of Discovery 1. Okay.
53 through 55.
Okay.
Judge, the issue that I'm having, I guess, is mine goes from 184 to, from 216 to 243, so apparently there's a page missing somewhere from what I have. I don't think it's the same document that we're talking about, I'm not sure, Judge. The notice that I filed with the Commonwealth that I indicated what we had, what we didn't have, goes from 184 to 216. And then from 216 to 243. This is in the middle. That's why I'm confused, Judge, about where it is that they say it was disclosed. That's why I want to take the time to look at it all and find out. This doesn't include everything that they're talking about here, Judge, in the same numerical order. That's the problem.
228, 229, and 230 in Notice of Discovery 30 is what we're talking about.
Right.
That's the reproduction of these same documents according to the Commonwealth.
I understand what the position is, Judge. What I'm telling you is the chart that I have in front of me, that I'm trying to make the determination of, goes from 216 to 243. The 220s aren't on this chart, and that's the concern that I have.
Does your co-counsel have the missing page?
Yeah, if I may, that is a document that we received from Attorney Scapicchio from her office.
Yeah, no, it's her document, yeah.
It is her document.
Yeah.
And that's the concern.
Does your
I have to go find out.
your co-counsel have the relevant page?
I don't have I have the same exact.
Here's the same exact document.
All right.
And that's
All
why
right.
I didn't want to waste the court's time, Judge, because it appears to not have everything that they're talking about. But it's possible for me to make that determination.
All right, Mr. McGee, you can continue.
By my same mistake.
Pointing you back to Notice of Discovery 1, there was a CSLI, so 27 and 60 on Notice of Discovery 1. What is that?
So 27 is a copy of CSLI PowerPoint for the defendant's number that was used during the course of the grand jury testimony. I believe it was marked
Number on that?
27.
What was the grand jury exhibit number?
I don't recall. It would have been around the same as 33
It's
through
not
35.
noted. And 60?
So I'm sorry. Item number 60 lists copy of grand jury exhibit number 44, PowerPoint of CSLI data from the same number as the defendants.
Okay. Are those the same thing? 27 and 60? If you know.
No, I don't believe so, because one is 7 pages, one is 8 pages.
Do you know why you would have provided 2?
No, the only thing, I haven't looked through the entire notice of discovery. There was a ranging data PowerPoint, but I see that listed as item number 28.
Okay.
So I don't recall that. Thank you.
I just handed you a document marked grand jury exhibit 44.
Mm-hmm.
Could you take a look at that, count the number of pages, take a close look at it?
Okay. 8 pages in length.
What do you believe that to be?
That's the grand jury exhibit number 44, which pertained to the CSLI in PowerPoint presentation in relation to the defendant's phone.
The defendant's phone ending in 6961.
Correct.
Okay. And which item on the notice of discovery does that represent?
That would be number 60.
That could be next marked as the next exhibit.
Grand jury exhibit 44? Okay, exhibit 19.
Was this provided to counsel?
Yes.
And counsel being Attorney Scapicchio?
Yes.
Notice of discovery number 28. What was that?
28 is the ranging data PowerPoint for the same number ending in 6961.
I'm sorry, this is notice of discovery 1, item 28?
Yes. What was that, ADA Lally?
So again, that was a PowerPoint related to the ranging data, which is a different type of data relating to the movement of the defendant's phone.
Okay. And how was that prepared?
How is that prepared?
How do you create a, if you know, how does ranging data end up on a PowerPoint?
So what you're essentially doing is taking the longitude and latitude points from the call detail records received pursuant to the search warrants, and then you're plotting them on a Google Earth image as far as where they would be geographically.
And so for this one, this came from records produced by T-Mobile in response to search warrant 21 SW306.
Correct.
And that was provided to defense counsel?
Yes.
In December of 2021?
Correct.
Or thereabouts? Notice of discovery number 1, line number 30.
So that is a copy of an Excel sheet of calls, sort of isolated from the call detail records, calls between the defendant and his girlfriend, the co-defendant, Ms. Gardner.
Okay. And if you know, how is that what does that Excel sheet of calls, how was that created, or what is it created from?
Essentially what we were looking for there was calls between the two numbers around the time of the homicide and immediately after, as Ms. Gardner was charged with an accessory after the fact, to show that there were communication between the two phones. So it was taking all of the call detail records and then excising out just calls between those two numbers.
Okay, and by excising out, you excise out, not you, but somebody excised those those from call detail records produced by T-Mobile in response to search warrant 21 SW 306.
Correct.
Do you know who that someone was?
Lieutenant Tully.
Okay. And would that same Lieutenant Tully have prepared the ranging data PowerPoint that was number 28 on Discovery number 1?
The ranging data as well as the CSLI, yes.
Okay, and all this was provided to council in December of 21? At
the defendant's arraignment, yes.
Okay. Did you keep copies of the ranging data PowerPoints?
Yes.
Or and the Excel spreadsheet?
Yes.
Okay.
They were grand jury exhibits, so yes.
Wait, this is what?
The document.
The docket of what?
The document in this case.
Docket sheet in this case? Yes. Hardly necessary, but if you want to mark it, you can mark it Exhibit 20.
Thank you.
This is as of printed when?
August 21st, 2026. At 10 a.m.
Okay.
Lally, could you take a quick look through there, just the number of dates you were in court?
The total number of dates I was in court?
You want him to add them up?
I'd ask him to review it.
What specifically do you want to ask him about the docket?
A couple of things I want to ask him here.
Go ahead.
I want you to look at grand jury exhibits 33, 34, and 35, marked as exhibits 16, 17, and 18 for this hearing. I point your attention to the last few pages of those,
Okay.
and then I'll ask you a few questions. Let's start with exhibit 16.
What's the question?
As part of those grand jury exhibits that were provided to council, what portion of those search warrants were provided to council?
So there's the copy of the warrant itself for
Search warrant.
for 21306.
Yep.
And the addendum A for 21306 is attached as well.
Not the affidavit.
No.
For grand jury exhibit 34, exhibit 17, same thing. If you could look at the last few pages of that exhibit, what portions of that search warrant, if you could describe it, which number it is, were provided to council?
Sure. So for exhibit 17, which was grand jury exhibit 34, it's a copy of search warrant 307. And again, addendum A for 21307.
And no affidavit was provided to council
Correct.
in December of 2020.
Correct.
Exhibit number 18, same thing. What was provided to council?
So exhibit number 18, which is grand jury exhibit number 35. It's a copy of search warrant 329 and a copy of addendum A to search warrant 329.
So not the affidavit for 329.
Correct.
And so when I asked you earlier about these exhibit number 2 of the search warrants that have bait stamps on them. This was not provided in this manner to council in December 21.
Correct.
It was just what was provided as part of the
Yes.
and also,
And the affidavits you referenced earlier.
and I'm going to talk about that for a second because I want to be clear that you mentioned that there was a 6-page and a 7-page.
Yes.
And did you keep copies of those?
Yes.
And do you know where they are at this point?
No. I mean, they would be with the file, but beyond that, I don't know where the file is. I don't know what's in the file.
If you wrote down on the notice of discovery that it was for a certain, at this point in time, in 2026, if you wrote on the notice of discovery that it was for a certain phone number, do you believe you provided the affidavit for that phone number?
Yes.
Is there a possibility it could have been a typo on the second line or on the first line, that it could have been for another number?
That's possible, I suppose.
And you don't have copies of those right now?
No.
Have you seen it, Cyber?
Sure. Yeah. Hey.
Wait for my client to come back.
Attorney Scapicchio, any objection to us proceeding?
That's fine.
Okay,
I'll update my client when he gets here.
great. Mr. McGee?
I'm going to move on to the tower dump search warrants. When did the state police seek the tower dump search warrants?
I don't know.
If I could just grab those while we're on this topic.
Exhibit 3.
Handing you, it's been marked as Exhibit 3, and I'm going to get all this out of here. As you know it, I've asked you to review Exhibit 3. When did the state police seat the tower dump search warrants?
So it was the search warrant issued on January 13th, 2022.
And that was when it was filed?
Apparently, yes.
And who was the affiant?
The affiant. Trooper Proctor.
And when was the return on that?
Return would have been January 21st, 2022, or that's the day it was sworn to.
And what was the return on January 21st, 2022?
The return was, data has not been returned by AT&T Wireless.
And just to be clear for the court, this is for all search warrants, 2022 SW 21 through 24, marked as exhibit. Same questions, same answers.
Yes.
Same affiant, same data filing, same data return, and same date and same information provided on that return on January 21st, 2022.
Sorry, I'm just confirming on the return. Yes. Same affiant, same dates, and same information return.
February 9th, 2022, you filed a notice of discovery, is that correct?
If you say so.
All right. I wouldn't trust my memory, but I'm going to provide it to you here.
This is notice of discovery 3? Is that right?
Yes.
Okay. Any objection to it being admitted as an exhibit?
No, Judge, I don't have an objection to any of the notices of discovery.
All right.
They're already all considered, Judge.
All right. This will be the next item. Are you moving it to, assuming you're moving its admission?
Yes.
All right, this is Exhibit 21.
Thank you. If I could point you to item number 4, copy of affidavit, support of search warrant for cellular tower dump records, 12 pages.
Yes.
Do you know what that was in reference to?
In reference to the affidavit, which was the same for each of the 4 search warrants from 22, search warrants 21 through 24, which is Exhibit 3.
So all the affidavits are all the same for all those search warrants?
I believe so, yes. They're just directed at different providers.
Okay. So why, if you know, were not 5 affidavits for 5 separate search warrants provided to counsel?
The only thing I can think of is that the affidavits were the same. Or the affidavit is what I had at that point.
But in any event, you provided an affidavit for one of those search warrants, you believe?
Yes.
In February of 2022?
Correct.
It looks as if yes, February 9th of 2022 is when you filed that. On August 29th, 2022, you were in court.
Okay.
And I'm going to make this representation. Your Honor, I'm not going to pull the transcript, and this is represented by counsel, and I confirm this in the transcript itself. You informed the court that there was a search warrant for some tower dump information that I haven't received anything back yet. If I said that was an accurate statement, quoted from that date in court, would you agree?
Yes.
Does that sound like something you would say?
Yes.
Okay. What did you mean by that?
I would mean that there had been a search warrant for some cellular tower dump information and that we hadn't received any information back in relation to the warrant from the providers at that point.
And what do you mean by information?
As far as data in reference to the tower dump.
Do you know when the data was returned?
I do not. I do not.
If you could. I hear it.
That should do it.
All right, let's try that. Go ahead, Mr. McGee.
Thank you. Do you know when it was available?
Off the top of my head, no.
Do you have any memory of speaking with Trooper Proctor about the data for those search warrants?
I know that I did several times because it was something that, you know, obviously I'd given counsel an affidavit, so it was something that was, she was aware of, the court was aware of as far as pending, so it would have been something that I would have gone back to him several times about.
March 14th of 2023. That's to be marked as Exhibit 22 with the Notice of Discovery 14. Standing no objection to the Notice of Discovery. I'm just going to approach with it, Your Honor, for this one.
Okay. You're not asking it to be marked. Okay?
I'm asking that it be marked.
You are. Okay, this is 14?
Notice of Discovery 14.
Okay. Is that 22? 22, okay.
ADA Lally, what's on Notice of Discovery 14?
So items 1 through 4 are a copy of the search warrant docket number, so that would be the entirety of the search warrant, application, affidavit, return, everything for 2221 through 2224. And then item number 5 is a copy of the tower dump data that was received in relation to the above 4 search warrants.
And when was that information provided and data provided? If you know.
So the reason I hesitate, so the Notice of Discovery is dated March 1st, 23. What I would do sometimes is, actually a lot of the time, is I would date the Notice of Discovery for the next court date, just to make it clear, but I would send whatever material I had. So the filing date is what I'm saying is probably closer to that than the actual date on the notice.
And the data that's on the CD, do you know what that was?
Exactly as it states, it was the tower dump data that we received in relation to the 4 search warrants.
Okay.
Attorney Scapicchio, I heard a lot about the tower dump data in the search warrants, and you're direct. Is there a contest as to whether that was in fact produced in March of 2023?
There isn't.
There is not?
The issue was whether or not they followed proper protocol in terms of notifying the court about the search warrant, notifying the defendant about the search warrant.
Okay.
They make any claim that it wasn't disclosed.
Okay.
So I don't really know what it's all about.
And I'll save that for argument.
And Judge, when I say disclose piecemeal in different parts, in different ways.
All right, Mr. McGee?
Thank you. Yeah. I'd like these to be marked as the next 2. I just want to note that Notice of Discovery XB1B I have an unsigned version, and I don't have a signed version from the docket, but I believe it to be true and accurate. I'm just letting the court know. I know the council's been attentive to it. Then what I propose is exhibit number 24 is state police report number 27. Last one. AD Lally, what are these two documents? Yep.
The first is the Notice of Discovery 19, which has two items on it. Copy of the State Police Report number 27 with an attachment, and a copy of a tower dump information in Excel spreadsheet form that was provided on a flash drive. And the second document is a copy of that report by Connor Keefe in regard to the tower dump records with the attachment that's referenced on the Notice of Discovery.
Thank you. I know this is unsigned. Do you believe this to be a true and accurate copy of what you filed for Notice of Discovery?
Yes.
XB1B.
Yes.
And that's marked as Exhibit 23, is that right?
23 and 24, if it could be so.
That's 23.
I believe so. We'll get to 20. Yes. Yes.
Okay.
23 is the unsigned. 24 is point. And just for the record, when was this item, police report number 27, provided to defense counsel?
The Notice of Discovery dates it at January 24th, 2024.
And thereabouts. And what's the date on the police report?
Date on the police report. I don't see a date on the police report. Oh, forgive me, January 19th, 2024.
So is it fair to say this was provided to defense counsel sometime between January 19th and January 24th of 2024?
Yes.
Thank you very much.
I'm sorry, you said the date of the document was January 19, 2024?
Correct.
Okay.
And what is that police report in reference to?
The same information, the tower dump records listed on Notice of Discovery 14, Notice of Discovery 3, and the search warrants from 2022.
Just want to make one thing, actually, we'll move on. The Ring camera. You testified earlier that you provided the grand jury with Ring camera video from a 45, what did you provide a Ring camera video from? Do you know the address?
No.
Do you remember the witness that provided it?
The name of the witness?
Yeah.
No.
Do you remember what the Ring video showed the grand jury? I know it's been 5 years. If you don't, I don't want you to guess, but if you don't.
Not specifically, just that I recall there being a police response. I recall...
So you don't remember what was on the Ring video?
Not perfectly, no.
When was the last time you looked at it?
Say 2022, 2023, something like that.
Nevertheless, it was provided in Discovery Notice 1, line 46, if you remember.
Sounds right. Thank you, sir. Yes. Item number 46.
Just to be clear, you did not know that a short, approximate 10-second footage from an hour before the shooting was possessed by the Milton Police Department?
No.
This is the first time you heard it today?
Yes.
Move on to the jail calls. This might take a bit. I'm asking to mark collectively what was previously provided to the court as Exhibit 3 to the Commonwealth's opposition to the defense motion from the trial, the first opposition. I attached 3 exhibits.
Is there any objection to marking these documents?
Okay. I don't know that I can read those as quickly as they want me to. I don't, the emails appear to be brand new. I don't think that they've been marked before, so I don't.
And I'm going to walk
minute
over
to look at
them anyway, but I can pre-mark it. It's fine.
I'm sorry, is there an objection or there isn't an objection?
I have to review it, so you can't.
Okay, go ahead.
I have emails on it that I have to look at.
All right.
Any packages of emails? Maybe, Did Michael Proctor request that you obtain the defendant's jail calls from the Norfolk House of Corrections?
Yes.
When did he do that?
It appears July 27th, 2021.
What did he say?
It says, Adam, I was thinking of obtaining the jail calls for King. Could you prepare the paperwork and I will get it to the jail? Thanks.
And that's represented in one of the emails that I just provided you?
Yes.
First page or so?
First page.
Okay. What did you do next?
I responded asking if there was any specific time period or just since he's been in custody, excluding attorney calls.
Okay. If you could flip through those documents a little bit. When did you serve the subpoena for those jail calls at the Norfolk House of Corrections? Or when did you serve the return for?
The return would have been for August 10th, 2021.
I know it's been a number of years. Do you remember if the grand jury was sitting that day?
They had to have been, otherwise I wouldn't have had the return for that day.
Okay. Do you know what days the grand jury typically sits on?
Tuesday, Wednesday, Thursday.
Okay. And why would that matter to you?
Because those are the rules as far as subpoenaing any documents to the grand jury, is that they have to be returnable on a day that the grand jury is actually sitting.
Okay. Did you learn that the defendant had moved to the Plymouth House of Corrections?
Subsequent at some point, yes.
Okay. Did you see an email about that in the package there? If I could point your attention to July or August of 2021. If there's not, there's not. Let me ask you this.
Not that I see, no, sorry.
You found out that he had been moved to the Plymouth House of Corrections, correct?
Correct.
And who did you hear that from? If you know.
I don't. Might have been Attorney Geary.
Okay. What did you do as a result?
So we did a second grand jury summons for jail calls from Plymouth.
Okay. And is that contained in that packet there?
Yes.
And when was the return date for that?
August 26, 2021.
And was the grand jury sitting that day, if you remember?
Yes.
Okay. Same reason?
Same reason they would have had to have been. That's why I would have picked that date.
I represented to you that you were before the grand jury on August 19th, 24th, and September 9th. Would you agree with me?
Sure.
Did you receive a response from either sheriff's office?
Yes, at some point.
Is that contained in the packet there?
Yes. Yes.
When did you receive anything from the Norfolk Sheriff's Department? If I could point your attention to exhibit, what you provided to the grand jury in 2025.
Sure. So exhibit number 2, is that what you're talking about?
Yes. So when did you receive the Norfolk calls? When did you receive the Plymouth calls? Or when are they dated at least?
They're dated or generated on, I believe, August 11th, 2021.
And which one was that?
The Norfolk calls.
Okay.
I believe it's hard to see if it's an 8 or a 9, but.
Okay. But in August of 2021, August 11th, you think it is?
I believe so, yes.
All right. What about the Plymouth?
Plymouth. Oh, I'm sorry. Return of service was 8/15/2021.
When?
August 15th, 2021.
Could that be a 2, or is it definitely a 1?
It's a little difficult. It could be a 2.
Okay. So on or after August 11th, 2021, Norfolk responded with the calls, and then on or after August 15th, 2021, or 25th, 21, Plymouth responded with the calls. Is that correct?
Correct.
All right. I mentioned those dates before. Did you return the Norfolk calls on August 19th or August 24th of 2021? And I'm talking about the Norfolk calls now.
No.
The August 11th calls.
No.
Do you know if you possessed them before those 2 dates?
I don't believe I did.
All right. Nevertheless, by September 9th, do you think you possessed all of these calls?
No.
When do you think you had them?
So I recall receiving the Norfolk calls sometime shortly before the grand jury voted. So that would have been in either late October, early November of 2021. The Plymouth calls I did get right around the time that's indicated on the return of service.
So that would have been sometime in August?
Yes.
Presumably could have been returned in September of 2021.
Could have been. That would not have been my practice to return them without listening to them.
Did you inform the grand jury of their existence before you voted?
No, not specifically.
We're going to have to leave it there.
What?
We have 5 minutes of at 1 o'clock.
Okay.
Okay. How much more do you have?
Say about 20 or 30 minutes,
Okay.
I hope. Might be a little bit.
All right. Mr. Lally, you're welcome to step down, but we're going to need your schedule. So you might as well stay put because we're talking about a next date.
Sure.
We need a next date to continue the hearing, and it may be that we have a further hearing on the issue of the second supplemental motion. I don't know if there's any evidence that's going to be required for that.
Because I think, I don't know if you want to hear the argument now, but.
Yes, I do.
At a minimum, Judge, I would want to introduce my expert.
You can do that by affidavit.
Good.
I don't have any affidavit from that expert.
I don't. Judge.
Who is the expert?
Her name is Dr. Lindsay Davis, Judge.
What is her expertise?
She is, I think I provided the CV to the Commonwealth, her CV to the Commonwealth. I did. I gave it to Ms. McGee.
morning?
No.
The day that we,
The day that you spoke.
What is her expertise?
In bias, cognitive bias, and explicit bias, Judge. One of the items the Commonwealth made.
I'm not saying you shouldn't call the witness, but you can do it in an affidavit. I'll take it by affidavit. I don't know why not. Any other witnesses on that motion?
Yes, I think there are a number of witnesses on that motion that we're looking to call. I thought we submitted it to the court in terms of why we wanted to call them. We're looking to call Trooper Proctor, as to who he might have shared his racist views with. He's already under subpoena for the last court case, so I'm happy to notify his lawyer as to what we want to talk to him about. And then, Judge, we had other witnesses on our list. I think there were 8 altogether. Attorney Hickman, we were looking to call as to when she took over the case, the status of the case, what she produced as a result of what wasn't produced to go to the failure of the Commonwealth to produce the records. And I think, Judge, we were looking to call.
That's not the second motion. I'm concerned about the second motion.
The second was the property subject, is that what you're saying?
The second motion is, the second supplement is all about Proctor and his racist views and what its impact is on this case, whether I should dismiss the case based on those racist views. And
the draft affidavit, Judge.
I don't either.
So that's why I do can call them as witnesses.
Have you talked to them? Have you called them? Have you tried to find out?
Have I called them about whether or not they knew Proctor's racist?
Yeah.
No, I haven't, Judge.
Okay. I mean, an awful lot of this is public record now, right? There are public reports about investigations of other police officers who are on the distribution list. There's all kinds of stuff out there.
Yes.
Okay? You can call them and see what they knew. But I'm not going to have an open-ended hearing where you get to call anybody in the world in the hopes, 8 witnesses, in the hopes that they might know something. You saw my ruling with respect to Mr. Lally and the question with regard to Mr. Proctor, Trooper Proctor, and I have the same view with respect to others. Okay? So I'm going to need an offer of proof as to what they will in fact say before I'm going to allow you to call them as a witness. Okay? And so...
The proof that I gave you is insufficient, Judge. Is that what you're saying?
It's not an offer of proof. It's just a subject matter list of what you want to have them talk about.
Right.
But it's not what you anticipate they are going to testify to. An offer of proof is what you expect them to testify to, and apparently you don't know what they're going to testify to.
Well, I think you have to lay the foundation, Judge, as to their relationship with Mr. Proctor, their interaction with Mr. Proctor, to be able to make the argument that we're anticipating making with respect to Mr. Proctor's racist and biased comments
So I'll take an offer of proof if you have an actual offer of proof, not just general subject areas that they're going to testify to. Mr. Smith knew Trooper Proctor in this capacity, and he will testify if called that he would say X. So this is not a fishing expedition. This is not a
fishing expedition, Judge. I guess I'm having a little bit of trouble understanding why you think it is. You asked us to list our witnesses. Are you saying that none of the witnesses that we listed are technically allowed to testify, and they all need offers of proof, like Proctor needs an offer of proof?
No, and we can put Proctor on for a hearing in a week, okay? Sure. And we'll see if he comes in and if he's intending to invoke or he's not intending to invoke. We can set up a schedule that works for him and everybody else to have him on the stand if he's not going to invoke. I mean, I'm going to have to figure out whether he in fact has a valid fifth, if he in fact is going to invoke. You say he's going to invoke. I'm not sure anybody else has said he's going to invoke. And I don't know if he will.
I said I believed he was going to invoke.
Yeah, I know.
I don't know that for sure.
He has counsel, right?
He does.
Have you talked to counsel?
I actually have reached out to counsel, Judge, in terms of the civil court deposition, not reached out to counsel in terms of a date in this case. No, Judge.
Okay. So I am hopeful that we could do this on a date in September when I can give you a full day, and we can have an interim date before that.
I just want to remind the court that Mr. King needs 10 days to notify the U.S. Marshals for transport.
Okay.
To the attorney's office.
All right.
Your Honor, who are you expecting at the full day? I do have the availability of some witnesses. If the court is anticipating, or is the court going to wait for an offer of proof by Attorney Scapicchio as to the witnesses that she has listed?
Well, the Commonwealth has witnesses too. I assume they're going to have to produce an offer of proof for the witnesses they want to call.
We did an offer of proof. We testified. What we put in our filing to the court was what we anticipated them to testify to, and that is, I understand, is a proper of proof. It wasn't the subject matter. It's just, there was information within our, and we could add to it more, Your Honor, but it was all spelled out in the Commonwealth's opposition to Mr. Defendant's second supplemental motion to dismiss relative.
All right, so let's just be clear about what we're talking about. The Commonwealth's proffer regarding potential witnesses is docket number 238. It was submitted August 20, 1 week ago, and it lists 3 witnesses, right? Colligan, Cherry, and Bullard, all of Milton Police, right? Okay, and they are going to testify as to specific items of evidence and how it was collected.
Your Honor, those witnesses...
So let me just, are there any other witnesses the Commonwealth is intending to call?
Your Honor, the Commonwealth would be intending to call those witnesses only if the court found that under the long cases and its progeny that we needed to establish an independent basis for the defendant being the target of this investigation. Those 3 Milton officers would testify as to what the victim said.
I understand. I understand.
If the court deems it necessary for us to do that, we would call them. If the court doesn't think it's necessary, we would not call them.
Attorney Scapicchio, the witnesses that you're talking about are docket number 237.
That's correct, Judge.
Okay, and
We filed that last Thursday as well.
I beg your pardon?
We filed that last Thursday as well, Judge.
Right, okay, and okay, Attorney Scapicchio, are you on trial next month?
In September, Judge, no, actually, that was a trial I had with Attorney Reddington, and it got continued down in Fall River. So
okay,
I'm not on trial.
so I have the day of September 22 fully available right now, I expect. And I would like to hold that date.
And inquire who, what I can tell the court is, Brian, if the court decides to allow the Scapicchio to call Detective Lieutenant Tully, he's unavailable on that day, as well as Detective Lou Ballard of Milton, if they are also unavailable that day. I'm just going to tell the court what the unavailability is at this point, that I've been informed on the last day when I made an inquiry as to the officer's availability for this case.
Okay.
So, Judge, I just want to let the court know, I do have a lobby conference on a different homicide in Fall River on the 22nd. I will move tomorrow to continue that, Judge, to accommodate this. I just wanted to let the court know there was a conflict.
We're going to hold the whole day of the 22nd for this hearing. We'll finish with Mr. Lally, assuming he is available on the 22nd.
You're available. As far as I know.
I'm sorry?
As far as I know, you're
As far as you know. Okay, great.
And I am available.
Now you can step down if you like. Thank you.
May I retrieve that? I'm not going to mark it today. I'll mark it next time.
Sure. Okay. You understand my rulings with respect to inquiring about Mr. Proctor to Mr. Lally. And my rulings are quite...
But I understand it.
I know you objected, but my rulings are going to be quite consistent, I believe, on that. And so I don't know if you're going to be able to call any of these witnesses for very much as it relates to the second supplemental motion. Okay, I just don't see evidence being necessary with respect to the second supplemental motion. I'm going to assume certain things based on your representation in the Commonwealth's admissions. You can submit an affidavit from an expert. I suspect we're not going to have to cross-examine the expert. If the Commonwealth thinks that we need to have the witness here and that they don't want to just take the affidavit, we'll take that up. But it does seem to me that anybody else about non-disclosure of evidence can be called as it relates to the first supplemental, the first motion and the first supplement.
Yeah.
Okay. But I think that that's very limited testimony. It's about documents that were not produced in the early periods.
Yeah.
Okay. And why? That's what's before me other than the Proctor racist stuff.
So Judge, are you saying you don't want me to file an offer of proof, or you do want me to file an offer of proof?
I'm going to permit you to call witnesses, okay, as it relates to when stuff was available to be produced, that wasn't produced.
Yeah.
Okay? And it doesn't seem like very many of these witnesses are on that point. I don't see any purpose in calling Ms. Hickman, okay, to be honest, because we have all of the notices of discovery post.
I disagree with that.
All right, well, I'll
cross-examining, but I disagree.
All right, well, I'll take that up if we need to get there, okay?
Yes.
But at least for the 22nd, Ms. Hickman is off the table. But other witnesses who might know about documents or items that were available earlier and not produced, and why?
The only one that would know about it is Attorney Hickman. She took over the case. She knows what the case looked like, what the case file looked like, what was in the file, what wasn't in the file. We've had a number of conversations about what was not in the file, Judge. And the testimony we heard today is nothing like the conversations that we had about what was and wasn't in the file and what Attorney Lally's memory was or wasn't. And those are all relevant to whether or not you credit Attorney Lally.
Okay, what does the Commonwealth say about that?
Your Honor, the Commonwealth had asked this court to quash the subpoena to ADA Hickman. She came into the case after the discovery violations that have been the subject of this motion. She was not a Milton police officer. She was not an MSP trooper. Attorney Lally testified that he asked for things, he didn't have them. And I suggest that her testimony as to what she did to get these is not relevant to what is before the court, the discovery violation. The Commonwealth acknowledges that
No. I mean, it is potentially relevant. The fact that she came in late doesn't eliminate the relevance of what was in the file when she took over and what was not in the file and what it took to get it. So if it took a phone call to get it and all of a sudden they disclosed everything and it's all covered, it's all kept online and it's no problem to get their whole online file, that would be relevant to whether...
Well, Your Honor, I would suggest in this case, again, Attorney Hickman is lead counsel in this case at this moment. What she produced to counsel is well documented in the notices of discovery. And there's no allegation of any failure to produce discovery by Attorney Hickman, and she can't peer into Attorney Lally's mind. I would suggest perhaps the Commonwealth could submit an affidavit as to what she did, if that would be satisfactory for the court. Again, it is extraordinary to call a prosecutor to the stand, and in this case, this is lead counsel now.
Prosecutors get called all the time with respect to nondisclosure of evidence, okay? This is a unique situation. It's a huge dump of evidence on the eve of trial or close to, before trial was going to begin. And why that happened is what we're about here, okay? Part of that is what ADA Lally knows, and part of it is what whoever took over for ADA Lally knows. So there is some relevance here. All right, I will review these witness lists again, and I'll issue a short order with regard to witnesses.
I'm happy to supplement if the court wants additional information, Judge.
When will you file the affidavit from your expert on the second supplemental motion?
I will speak to her today, Judge. I would say within 10 days.
Okay.
I can get her affidavit to the Commonwealth. And my understanding is, Judge, we did provide the Commonwealth with her CV the minute we identified her as a witness. And I only identified her as a witness after the Commonwealth filed their opposition, claiming that the bias of former Trooper Proctor may not affect his ability to investigate as an agent of the Commonwealth.
Okay, I will give you a ruling. We'll have a hearing on the 22nd. We'll hold the day. We'll start with Officer Lally. I would like to see you before the 22nd, though.
Can I subpoena Trooper Proctor for that hearing date?
I want to see Trooper Proctor before that hearing date.
Sure.
Okay, so I want to set another date earlier And I want to make sure you get in touch with his lawyer. If we need to issue a subpoena, you can issue the subpoena for that date. But
I don't
want
think
to
we
know.
need to issue a subpoena, Judge. You recognized him last time he was here and told him he'd have to come back. So I don't think you need to issue a new subpoena. I just think I need to notify his lawyer of the date.
Sue, can we pick a Monday or a Friday at noon to do the hearing? This is really a status hearing, but I think we can get Mr. King in for that, so long as we give 10 days notice. And I think we can deal with everything we need to deal with respect to witnesses and what have you, in that kind of time.
Your Honor, given the schedule and the fact that we need 10 days' notice, I think the earliest we could do it is the week of the 14th.
Can we do the 14th? That would be great.
14th, I have an argument at the SJC on a homicide case, Judge, that was supposed to be first out, because I was supposed to be on trial.
All
I
right.
notified the SJC that I was not on trial, so I don't know.
How does our 2 o'clock look on the 14th?
2 o'clock?
I'm just looking at our list. That's doable.
It's doable.
Yeah, okay. Why don't we do this at 3 p.m. on August 14? We'll see if we can work through our 2 o'clock list.
Sure.
And we'll do
That'll be
this
enough
with,
time to get Mr. King in with the federal
I'll issue
government?
the Hague today. If we do it like we did last time, we can hope.
we'll give it a try.
We can only do.
Yep, yep.
Donna, there's 2 other housekeeping, and I appreciate that we're now looking at 113, and I appreciate everyone waiting for lunch. But we did have 2 protective orders that were filed. Your Honor, I do believe there are no objections to these protective orders, but for the fact that we need to work something out so that we can provide the materials to Mr. King, who is in custody.
Yes, Judge. So there's a paragraph 4 of the protective orders that say that my client can't get any copies, that I have to sit with him and review it. There's been other disclosures to Mr. King while he was in and out of custody, that he would be able to look at this material on a USB drive. We worked it out with Mr. Johnson, that the jail can keep custody of those USB drives. I've asked,
I want to, before you argue, let me just see if I can find the motions, because I want to make sure I have 239, which is Commonwealth's motion for protective order. These are materials in response to the August 12, 26 motion.
Correct, Your Honor. And then yesterday.
And there's no opposition to that?
to the protective order?
Yes.
No, Judge, except to the extent that I can, or the Commonwealth can put that information on a USB drive and send it to the Plymouth Jail so my client can review it.
Is there any objection to it being provided to Mr. King?
No, Your Honor.
Okay.
And that's the same thing for both protective orders, Judge.
And what is the other protective order?
This one is what I received yesterday, Your Honor. Protective order.
Who'd you receive it from?
It was drafted by the Massachusetts State Police. There was a defense motion for discovery relative to Michael Proctor, and there was a personnel file that is not public record material. State Police is agreeing to turn this material over to the defense pursuant to protective order. Ms. Scapicchio was in front of Judge Boudreau yesterday.
All right, so I don't know if I have that motion.
I'm asking Attorney Scapicchio to sign it now. Judge
I can do that,
Boudreau
Judge.
allowed this yesterday in Suffolk Superior Court when he heard the Johnson matter. What was raised as an issue with both of these, Your Honor, is that Mr. King is now in custody. The 2 protective orders that we're presenting to the court do not take that into account. Now, in the case of Commonwealth v. Johnson, Your Honor, paper 143, back on December 10th of 25, Your Honor issued an order in relative to Mr. Johnson that he could get a copy of Michael Proctor's personal phone, but it had to be kept by the facility and he couldn't make copies of it. We would be asking for the same type of order for Mr. King relative to Michael Proctor's personnel file, as well as the other materials that were requested relative to...
All right, so let me, with respect to both of you are agreeing to the protective orders.
Correct.
And both of you would like me to authorize Mr. King to get a copy. It can be sent to the facility, and he can look at it at the facility at his leisure.
Correct.
And he can't make copies of it or distribute it.
And I would put both of those 2 productions on one USB drive. Attorney Scapicchio told me it just needs to have Mr. King's name on it for the facility. But we would agree to put it on one USB drive so that Mr. King could review those 2 productions.
Okay, I'll take a look at both of them and get an order out today.
Thank you, Your Honor.
Okay?
Matters continue to September 14th and September 22nd. The process will issue for Mr. King for both days.
Thanks, Your Honor.
Thank you.
Thank you. Get up, get up.